memory. This is concerning that living will.
Correct. Where Datar case.
Yes. Where a person makes a will that in case if I am in coma or something, don't put me on ventilator, etc. My lords were pleased to, long back, issue certain directions, and it was the case of Mr. Datar that they are not workable. Thereafter, your lordship would recall last time we agreed that we'll have a joint meeting. But we had a joint meeting. The secretary and other senior level officials, who some of them were doctors also, DGHS and everybody, my lord, were there in the meeting. It was a very positive meeting, where we also agreed that some of the steps which are stipulated are not workable. That we also agreed with Mr. Datar's contention. Now we have two models before us. One is, my lord, given by Mr. Datar. Another is the model prepared by the AIMS, Delhi. So, my lord, there needs to be some consultation at our end with some experts. We'll sit again and we will find out, my lord, some common.
Yes, but we had a meeting, briefly, as the solicitor says, this question of signing it before the judicial magistrate after 3 panels of doctors, it is not going to work. I mean, in a practical situation, in Madras or Bombay, nobody is going to get the judicial magistrate to be there, and after 3 panels of doctors, so we agreed. Now, what they are saying is the health secretary and the DGS will go through we are given a flowchart. What could be a simple way of solving it? They have
Finally, what are you suggesting?
Finally, I'm suggesting, my lordship, I have it in January. So we'll again sit together over the December, because I think now only hardly time is left. There may not be time now.
No difficulty.
So my learned friend would agree. We are not, my lord, meeting. But we are not meeting in an adversarial. My lord,
Yes,
friend would agree.
But I was just suggesting for lordship's kind convenience. My lord has posted the WhatsApp matter constitution bench in January. If it can be put on that day, because the bench may not sit on a daily basis.
That's right.
Your lord,
Anyone
may not have to.
We can put it on that day.
Yes,
that I do the IT number.
3, my lord.
503.
503. I'm sorry, 50.
Solicitor General.
You should record that there is a consultation going on between.
Yes, yes. That's it. Solicitor General and Sri Ashwin Datta, who appear for the respective parties, will point out that pursuant to the earlier order dated so and so. Order dated. What is it? So was there an order? There is an order.
Order.
There is an order.
That we meet together.
Earlier order. Just take that time. Last day it came. Efforts have been undertaken. At present, the matter is engaging the attention of the AIMS.
No. The central government.
Ministry of Health.
Ministry of Health.
Union of India.
Union of India. Some more time may be required.
So that we will, what we are thinking is, if we both can come to some consensus, we place the guidelines before the court.
We will not trouble your lordship. We can assist your lordships for your lordships approve.
And then your lordship will modify it or whatever.
Yes.
We are completely at item. We are the original petitioners.
The
common cause.
Original petition.
Original petitioners.
But you will also be,
We are completely at item with the critical care doctors. We feel that those directions are very cumbersome.
That's right.
Need to be simplified.
We also heard, you can see Prashant Bhushan.
Me and Mr. Bhushan are also at item.
That's right.
In bold letters.
We are
all parties are either.
Yes.
Only one request. Dr. Kishore is here. He was involved in drafting the Organ Transplant Act, and his books and articles have been referred to by Honorable Justice Deepak Mishra and other people. So he has got a lot of material. There's a difference between terminal illness and incurable illness. What is death? So there are legislations of Oregon, etc., which we all consider. So he also wanted to say a few words, lordship may subject to my lord. At that time, we'll see in January.
That time we'll hear it. Not today. Sorry. Last sentence. As also Sri Prashant Bhushan appear to be an item that further efforts may have to be made to arrive arrive at suitable guidelines,
Draft guideline.
draft guidelines,
Because
which can be placed before.
yes, before it becomes guidelines only after your lordships approve.
Correct.
The lordships may modify.
Placed before this court for consideration of this court. Matter will stand listed to that day on which the other
I think it's
matter.
17th
17th
January or 23rd January.
17th.
17th.
17 January.
That WhatsApp date also.
That's right. That's over.
Lord, I want to make a submission. I'm a medical field diversified into law. I was a doctor for 40 years.
Which side, which medicine?
Dr.
side you are?
I am Dr. R.R. Kishore.
No. What's your specialization?
Your specialization.
I am a radiologist.
You are a
I was
radiologist.
a physician for.
Are
30
you
years.
specialized in
Then I
radiology?
specialized in radiology.
Are you specialized in any particular
Yes,
branch?
I
Are you general radiologist or a?
am a radiodiagnostician.
That's right. We follow that.
I'm an oncologist also.
Okay.
Now
I
I'm a member of the bar since 2004.
Yeah.
I have worked in this area of end to life, right to end life for a quarter of a century. And many of my articles have appeared in leading
Yes.
international journals.
Very good. Yes.
When the Honorable Justice Deepak Mishra was heading that bench, he requested me to assist the
Correct.
court.
Correct.
And my articles have been referred in the judgment itself.
Yeah.
So I would like to be associated with the
What do you want? We have actually,
Yes.
So my name may be mentioned in the order so that I may be a part of this exercise of debating this
But
entire.
he has done a lot of work. He's gone to
So
different.
he will be associated.
Let it come in January.
No formal this.
also heard. So
Dr. R.R. Kishore.
RF Kishore. We also heard. You can just put it that.
But I would, my lord, ensure that he is also participating.
Absolutely. This is
No,
not
no, it's a
adversary.
very part of the business.
As you pointed out, this is not adversary.
No, and my lord, the officers were also my lord, very, very cordial and very positive.
Very good. In
And
fact,
now it-
there are also safeguards in organ donation. That also, so we are trying to put in those safeguards.
Very good.
Yes.
Very good.
Obliged to.
501.
So we are just keeping in mind the time limit because we propose to start the
I-
Vedika too. We are not
I-
imposing, we never.
No. I understand. I mean, some of those peripheral areas sometimes assume some importance that we have to address.
Go ahead. Please go ahead.
Right. So, Elosh, kindly pick up this information.
Yeah.
This is on, with reference to what Elosh has shared with us yesterday. We now have a complete picture on this. Now, if you look, before I take a loss with that, one broad statement I would like to make before I take a losses to this.
Yeah.
Now, I would probably call 1991 when the act was enacted. Post 1990, Dinesh Goswami's report.
That's right.
Your act put in position.
That's right.
Prior to that, there was 1972, 1989. There was some legislation.
Correct.
So I would probably call 1991 a watershed. The period prior to it may have a different circumstances, environments, compulsions, needs, and the country moving towards a civilization of the democratic and electoral process. The Dinesh Goswami's report comes, and thereafter, if Parliament has applied its mind and has gone in a certain direction, then the question that would arise is, post 1991, we are not going back anterior to 1991, therefore post 1991, even after application of mind by the Parliament, the law coming into position, whether that law has failed in its object of ensuring the independence of the election body.
Which law?
1991 Act.
1991 Act is traceable only to 224(5).
That's true. After Dinesh Goswami's report. That is the 1990.
True. But we are saying, see, 1991 Act, if you have that Act,
Yes, yes.
you'll see from the very long title, it speaks about terms and the conditions of service.
That's right.
It doesn't deal with appointment. Only incidentally deals
I'm
with
aware of that.
term.
I'm aware of that. But the conditions of service, namely a tenure, remuneration. I mean, like in the context of independence of judiciary, these are two fundamental conditions. So these two conditions may run across many of the institutions where an independence is to be secured. If these two basic conditions are put in position, a third condition or a fourth condition may or may not be strictly necessary for the purpose of ensuring independence, unless the court has to travel further that any one of those additional conditions are so indispensable. So that is the additional factor the court may have to look into. So where assume the court or even Parliament thinks it is indispensable, but doesn't rule on that. The next stage will be this indispensability having not been addressed. Is there in a given case, in a given circumstance, in a given case, is there a matter for consideration and a matter for concern? So if there is no such circumstance or a case where a third or a fourth or additional condition would have made a difference and would have added to the security, independence, etc., that's how the court will probably go in. I thought I'll flag that like that. Therefore, these two conditions, the security and remuneration, are taken care of. And as long as they are taken care of, it's only in a given situation when there is any other aspect of a matter, which would be a matter for alarm, a matter of a concern, and there is an abuse of a position, process, etc., then the court may enter into it. I find that
Straight away, we will flag two issues there.
yes,
See, you appoint a yes man. Just going to the
yes. I'm
example of
only
just giving the example.
yeah, Lord.
Not that we are suggesting that you're doing it. You as a government, any government
Yes,
for that matter, it appoints a yes man. Somebody carefully picks him up. Somebody who is like-minded, has an affinity of thought, their philosophy. So they will do their, whatever they're building, they will do it. They know it.
no, Your Lordship, sir.
You take him,
Right.
You assure him security. You assure him both the other thing under the surface proviso 324(5), namely his conditions. On the face of it, everything is fine. Doggy. So perfect independence is what is the quality which is lacking?
Absolutely. I mean,
The quality which is lacking
Absolutely, no,
goes to the core of the matter, which is whether the man is really independent. See, there are various virtues, like in the American statute, it speaks separately of an amalgam of various virtues, one of which is independence. The most important thing is independence for certain institutions.
there
You
can
don't
be,
require that independence for a member of the parliament secretary. You don't require quality. See, the qualities of various qualities are to be judged with reference to the post that a person knows. For example, judge is supposed to be independent. I may be the most competent person. I know everything. But if I am docile, if before the government I become weak-kneed, when I have to take a stand, when I will risk my life, if it is so, then it is that quality which is
Quite right.
required.
quite right. Let me try to further expand on
So
that.
appointment there it is important.
Absolutely. I mean, all these are aspects which will definitely go into not only a thought process, but also in their application. I quite see that. I'm not saying disagreeing with that. But why I thought I'll start it is that the question of pick and choose or appointing a person of what some Justice Frankfurter called spaghetti spine. So we are not, therefore, if there is a room for doing that, and if there is an actual occasion when it has happened like that, then the court may enter into the picture. Why did it happen like this? How is this happening? The occasion for examining that issue will then arise. So on a premise that because that additional third or factor is absent on a premise, there is every possibility of a yes man being chosen or somebody, again to use the same expression, the spaghetti spine person being chosen. That will arise only if there is an actual demonstration in a given case. So for the court to probably say that we have an experience, I'll presently show what's happening in Pakistan. So we'll have an experience, despite the best of models, if something else is happening, then you're looking at the experience, not merely at the model. And we look at both of the model and the experience together. That's how I think the court would probably look at it. Therefore, I want to flag that post 1991, and particularly in these batch of cases, I am not able to find anywhere a trigger point which could be said to be an alarming situation where the act has been subverted or the process has been subverted for the purpose of picking up a person who would be an abiding, who will abdicate his office and so on and so forth. I don't see anything in any of these petitions. The broad speech of the petition is, here are a set of reports. These reports come under acceptance. We don't see why they have not been looked into. High-level bodies, law commission reports, I think they should deserve acceptance, therefore look into them. Therefore, it's very important that there is somewhere in several, while we certainly articulate the role of the court in important fundamentalized violation cases, but certain other areas where the role of the court would be certainly important for the purpose of looking at various policy measures. Look at today's, we are not even saying that because of global impact and a variety of aspects, the governance issue is so complex. So therefore, keeping all that in mind, the court's intervention in very important areas of governance would certainly be welcome. And they may add to the quality of governance. That's how the court plays a role. And I don't think an attorney can say no to that. I'm very clear on that. But I only want to say this line which will be drawn by the court when the trigger point is very important. If the trigger point is not there, for instance, the Anjali Bharadwaj case, the right to information office, there was a trigger point. Vacancies were there. Appointments are not being made. So if there is a good trigger point, and that will certainly arouse the anxiety and concern of the court. And that then have a duty to assist the court in the best manner possible. But I say there is no trigger point in this case. Now let me take your lordship through this sheet of paper. If we look at in the date of birth column, just go through that. It is invariably on the basis of seniority of a civil servant. Except, for instance, in serial number 14, there was one solitary instance when 14 and 15. So Mr. Anup Chandra Pandey, 59 cadre, came to appointed later, person appointed earlier. That's the only one solitary instance. That could be for a variety of reasons. We need not to guess on why it has happened. Then coming to the tenure as election commissioners, Krishnamurthy from January 2000 to 2004 as election commissioner, then an elevation from February 2004 to 2005 when he attained the age of 65 years. So he had a tenure of 5 years, so and so, in the election body. So we are looking at the total tenure of a person in the election body, not merely as chief election commissioner. Because the body is composed of election commissioners and later on being elevated as chief election commissioners, we are looking at the composite body as a whole. So you'll also find therefore in every almost except 2 or 3 cases, again looking at the case of serial number 6, 7, and 8. Mr. Sampath had a tenure of 5 years, 8 months, virtually bordering on 6 years. Now the rest, then Mr. Sampath, Brahma, and Mr. Nazim Zaidi, they all were appointed during the earlier governmental period, and they continued after this government was voted to power. Therefore, there is no interference as far as the security of tenure is concerned. Then I will look at, for instance, those cases were a 2 year, 3 year, 2 years, etc. They're all cases where they were reaching the age of 65 years. So one could say why you can't choose somebody who may have a 5 year, 6 year tenure. That could be one matter for consideration. Perhaps it all depends on which is the best possible person who reached a particular stage in the civil service career. How do you pick them up? So there is some element of locating the best ideal possible, I think, must have gone into this. So unless, again, as I said, in a given case, this particular location of this
For
person
example, how did you
is
appoint,
wrong.
Sunil Arora at serial number 11.
Your Worship, please, sir.
He is appointed in 31/8/2017.
11.
That 31/8/2017.
Yes.
He served for 1 year and 4 months as election commissioner. Then he takes over as a chief election commissioner from 18 to 3 years.
3 years.
So here it is slightly different. He gets a longer term.
That's right. So these
notice-
permutations and combinations may not necessarily lead
That's
to a conclusion that there is a tenurial insecurity.
Not insecurity. You have, yes.
Or even put it the other way, that this tenure is being handled in such a way that you have a person who would probably say, I don't think those considerations.
A person who's appointed as an election
Yes.
commissioner, does he necessarily have to become the chief? Is it a promotion? What is it? Does he automatically become
On elevation, on seniority.
on seniority?
Seniority.
So is it laid down? Is it something which you follow? As
No, there is no discretion there. On seniority, you get elevated.
You get elevated.
Yes. You become a chief election commissioner.
There is no elevation.
I mean, I'm using the word in a good sense.
After what you meant, see, after the judgment in Sessions case,
Yes.
where he said that actually this first among the Dhanua case, that is the first judgment of Justice Savan, where Lordship
Dhanua.
Dhanua, that the chief election commissioner is not even the first among equals because he's on a different higher pedestal.
Yes.
So that theory was actually sort of demolished in Sessions case.
Session has
They are equal. So when you actually went from a position of equality, when you move, you don't move vertically. Where is the question of his being elevated, or what do you mean by this process? And what is the process of appointment? Would say the only traced to 324(2). So are you then hidebound? Whenever somebody is there as an election commissioner, it becomes his legal or a constitutional or whatever right it is to become the chief election commissioner. So would you then be rewarding somebody with, say, for example, inefficiency, with somebody who is mediocre? Then do you?
No, then comes.
Yeah, just
I know. I understand that. I understand that.
Don't
I
take
mean,
it in any
those
other way.
considerations again will certainly guide. But if you have to make it either flexible or inflexible, Lordship knows in every institution, flexibility sometimes add a certain strength. Sometimes inflexibility impedes. Therefore, if you want to have a greater amount of flexibility, overlooking a person who might have been shown to be inefficient, then they become subjective factors get into them.
So then there is another problem. The moment you pick up somebody as election commissioner, now he is the person whom you're targeting to be the chief election commissioner as well. It's all rolled up. In other words,
That's true. That is true. That's why I was trying to look at this. I was trying to find out what best one can draw from.
take the constitution. Constitution for each one of us.
One more thing, when you said,
I'm sorry.
one more thing, when you said that it is by virtue of seniority.
Yeah.
Then only one doubt.
Yeah, Lordship.
See, a person while working as an election commissioner
Yeah.
is not having that kind of an immunity in the matter of removal. But automatically when he reaches the other post, he is having that immunity. Because in the case of a Supreme Court judge, only after following such procedures, he can be removed. So that means, now, what is the basis for them? Because as
They're all inbuilt.
if they are equals,
No difficulty at all. There are inbuilt principles that are conveyed. Therefore, if an inbuilt principle that the security of tenure is there, is implied. And you don't need to look at it expressly. Therefore, in a given case where an inbuilt principle is violated or breached, then comes the question of why are you doing it? And how have we done that? Therefore, I don't think we Your Lordship, please.
Attorney, our request is please take instructions again.
Yeah.
We are recording your statement that after the election commission's appointments are made,
Yes.
that senior among the two is being appointed as a chief election commissioner. It is your statement. Please take instructions. We'll record it. And if you are making election commissioner as a chief election commissioner, what is the guiding factor according to you in making an appointment? Only seniority among the two?
Yes, seniority. That's what we are.
Seniority.
That's all it is.
All right. And what is the mechanism in appointing election commissioners?
So that is again a procedure which is being followed over a period of time. There's a convention. You
What
have,
convention?
I'll just come to it. I'll just explain.
Because if the entry level is in your system is election commissioner, and only the election commissioner become a chief election commissioner.
Right.
So there is no independent mechanism available to consider other than the one who is not election commissioner.
Then comes the
So
question.
you confine to election commissioners alone for the purpose of appointment of election commissioner. And that man has already served
Yes.
into this election commission's business for 2 years, 3 years, whatever the role is. As and when the vacancy of election commissioner is available, then only do one thing. Show us what is the mechanism you put in place for the purpose of your entry level as election commissioner.
Yes.
If this is your stand, so we don't want to go ahead open selection process for a chief election commissioner because the entry level is election commissioner. Make it clear. Make it
The
clear.
entry level is election commissioner, but there is no direct appointment as the chief election commissioner.
There is no bar here.
That is the position.
In fact, that was what was being done for 40 years.
Exactly.
That was the concern of session. The
After
concern of session was that you are really eating into the sort of independence of the chief election commissioner. You're corroding the independence by this process of having two election commissioners.
no, and that's why
That was the whole idea.
whatever
That
session,
was-
TN session, pre-TN session era is now a closed
That's
chapter.
40 years.
It's now a closed chapter. A lot of lessons have been learned. I'm sure the lessons have been learned from our side. I don't think that needs to be a matter of concern. That's, I think,
The point.
I also looked at
The point therefore.
Your Lordship.
The point therefore will be, if this is your submission, the procedure that we may consider putting in place will have to relate to the appointment of the election commissioner. The reason being,
I see that. But
if
there may be,
he is going to go up the ladder automatically in terms of seniority, the appointment must be scanned at the stage of the election commissioner, not the election commissioner. The prayer will have to be changed.
no, I try to visualize how best a legal framework put into position in 1991 would be put into place, and in order that the executive gives an assurance that there is no playing with the law. How best one looks at it. Therefore, how many rules, do's and don'ts will you bring into a body like this, an appointment? So how can it be compared to any other bodies and institutions under the Constitution? So I don't think a mechanical comparison, even sometimes broad comparisons may work. Some institutions may be looked at in isolation. Therefore, it's important for us that as long as the bottom line is, if there is a scope, suppose somebody has challenged his 1991 Act and looked at the circumstances when there has been some element of deviation, breach, abuse, then the court would occasion to see why, what are you doing? How is it being done? My only difficulty is since none of those dimensions have been presented to the court and there is no such aspect to do before the court. The anxiety and the concern is how best we can suggest something so that whatever is not seen, whatever is not perceived, right, by the court or by us or by the citizens, why don't we look at it and see if something can be added? That's where I think the court's concern seems to come in, if I'm not wrong on that. So I was just looking at this figure and to find out if this figure does not demonstrate, does not show that the 1991 Act or even 324(2), the repository of constitutional power, has been put to any, exposed to any abuse, then perhaps the court will be very slow to go beyond that. Very slow to go beyond that. And I wanted to show how, for instance, the next sheet of paper. So we have the Pakistan model where there is a consultative process. and there is either a judge of the Supreme Court or a judge of the High Court is to be. So despite all that consultative process, kindly look at this scenario. The total time. There are people who have spent 49 days.
1 month.
So it may depend on when a person is chosen. And there are persons with 1 month, serial number 13, 14, they're all 1 month.
Lot of judges.
So I didn't
Most of them are judges.
why I wanted to bring this comparison is there is a different model there, a consultative process. You have an element of a person who held the office of a judge of a Supreme Court or High Court. So even in that consultative model, if persons with tenures of service which can be as low as this, then it is not really the model, it is the actual working of the model. So therefore, merely to suggest there is an ideal model elsewhere, you borrow it, would be a very weak proposition to be suggested. Would be a very weak proposition. And those models, as we saw, Canadian model was considered by the Constitutional Assembly. The South African model came much later in 1996 when the South African Constitution came in. For what reason they have a consultative model? The apartheid, the entire history of South Africa, which needed a complete paradigm shift in governance. Or take a country like Albania much later, or countries in Europe or in Asia, South America, where you have fragile democracies. So in those fragile democracies, we pick up a model may be good, but democracies do not work. Therefore, say a mere model elsewhere, as a constitutional model, except supported by good experience. In the absence of a good experience, a model by itself will not be suggestive of a great change and an important change from the current disposition.
Attorney General, at the end of the day, what they are suggesting is perhaps not as ambitious as you are apprehensive of. What they are suggesting is only filling that perceived vacuum.
Yes.
To the extent of having not this a councillor minister, picking up somebody and then doing it. Just have the Chief Justice, for example, of India, who's credentials.
Absolutely. I'm nothing to disagree on that. I quite see that. But
once you have that,
yes,
that is the only area that we can possibly come in. We also are conscious of it. We can't be obviously making an invasion on the Constitution. Constitution has to be respected. That's why we have a constitutional code.
Absolutely.
So we have to do that. That is the only area. You need only sort of concentrate on that.
Whatever falls from the constitutional code is a matter of great deference. I think it must be received with utmost sincerity and that.
That's all that we are suggesting.
Yes,
Not that we'll have complete takeover of your. We can't do that because it's a constitutional government. It's the Westminster model where it's a cabinet advising and actions are taken by the president in accordance with that, and we know that.
No, I'm not
saying that there is a small gap in the sense that in view of the number of reports which have spoken in one voice, political parties spokesperson have spoken in one voice.
Yes,
because they know on the ground reality. Like you said, the model is there, but how is it acting on the ground? How is it being used by the politicians on the ground, irrespective of whichever party they may belong to? That calls for reform. So whether, as you said, reform, we should wait for Parliament to wake up and see the need, which is very unlikely for the reason, very good reason, that we told you yesterday. Each political party in power would like to perpetuate itself in power. So they'll put it off. Okay, let the next government do it.
Right.
We got a good man. We are sort of having a very good relationship with him. He'll do our bidding. Things are moving fine. So nobody wants to walk that extra mile to bring in the much needed changes. That is the only area where the court may have to step in.
I wouldn't, in principle, disagree with that proposition because I think that's how we assist the court, and how do we reach that if there is a point for reaching. Certainly, that's how we assist the court. I certainly no disagreement on that. But to have that concern repeatedly being brought about, there could be shifts in the nature of governance and quality of governance. And then very often, I would probably put it at like this. I may just take you through a supplementary note which I have prepared and then take them and try to proceed further in order to save the court's time. And as your lordship seen in that sheet of paper about this, they're all, before I read that, in this, may I draw your lord's attention to the sheet of paper once again?
Yeah.
The details of tenure of election commissioners, etc. They're all people at the secretary level. People who reach in secretary level, and there's nothing like going down below to pick and choose. The importance is the length of experience people might have had over a period of time. And you lordships know that a district magistrate is an appointment to the collector, is a returning officer, and then they become electoral commissioners at the state level. So they gather this experience about election matters over a period of time. They might have thereafter been disposed to some other positions are there in central government or even state government. Many of them will become chief secretary, they work as an important position. Therefore, in principle, highest level of secretaries, chief secretaries, retired officers, they are all considered for the purpose of the appointment as election commissioners and chief election commissioners thereafter. Therefore, there is hardly any occasion when there has been a shift from this convention. The convention is scrupulously followed. And that's a very important aspect to be kept in. Now, let me take your lordship to this. I will also give it to the floor. Every person was right from yesterday, lordships talked about Sukumar Sen onwards, Nagendra Singh. So the background profile of each one of them, I thought I'll place it on record so that
Even-
the court has I will not currently trouble your lordships into.
And even while you say that with respect, after going through this,
Yeah.
that all these persons were actually functioned at the secretary level. But it would be indicative of one fact. Now, all along you were only looking into the bureaucrats for this post.
Correct, they're all civil servants. Civil servants who reach the level of a secretary of a department. So
All along only.
Now let me take your lordships to my note, supplementary note.
Yeah.
No case has been made out on facts, namely materials to show that the appointment of a chief election commissioner or the election commissioner so far, subsequent to the Election Commission Zones Act of 1991, are open to question by reason of extraneous factors or abuse of process. There is nothing to show that the independence of the Election Commission has been compromised by reason of the appointment process. As already explained, the focus of the report of the Committee on Electoral Reforms is as contained in para 1.6. Item number 2, referring to the strengthening the Election Commission and securing its independence, is not premised on any materials regarding concerns relating to the independence of the Election Commission. However, the recommendations towards securing independent election commissioner contained in paras 1.1, 2.2, 2.4, and 2.5. These recommendations now find their place in the 1991 Act as well. As far as suggestion contained in para 1.2 regarding mode of appointment, it's a shift from the position obtaining under Article 324(2) of the Constitution. And that's a matter entirely for the executive to consider, taking into account the compulsions, if any, to switch over to the mode so suggested. On this aspect of the matter, if it is respectfully submitted, there cannot be a positive direction directing the executive to proceed to act in terms of the recommendation. Then chapter 6 of the report number 255, the Law Commission dealing with the subject of strengthening the Election Commission of India, takes note of the Goswami Committee report and after a brief reference to positions obtained in certain other countries, proceeds to issue recommendation para 6.12.1. The Commission adapts the Goswami Committee model with certain modifications, as may be found in para 6.12.2. The premise set out in para 6.12.1 that executive interference can imperil the neutrality of the Election Commission is not based on any material, but is purely propositional. As far as the recommendation para 12.6.3 is concerned, it will be placed on record that the elevation of election commission, using the word very decidedly, as chief election commissioner is in the base of seniority, Therefore, it's clear that none of the reports relating to electoral reforms which suggest alternate modes of appointment of the election commissioners provides any material discussion that the current constitutional scheme under Article 324(2) has in any material way affected the independence of the election commission. Neither is the 1991 Act under challenge, nor is working, nor have any instances of improper appointments under challenge based on relevant materials. In such a situation, the question of entering into any critical evaluation of the working of Article 324(2) or the inadequacy of the 1991 Act does not arise. None of the serious compulsions for the need for the court's intervention, as discussed in paragraphs 26 to 29 of Vineet Narayan, are found in the present case. By convention, it's been established that the members of the senior civil service or the serving retired officer the rank of Secretary to Government of India, Chief Secretary of State Governments have been appointed to election commissioners, and senior most election commissioners, the Chief Election Commissioner, on the basis of database maintained by DOPT. A list of serving and retired officers in the position of Secretary to Government of India, Chief Secretary, is prepared. On this basis, the panel of names is then prepared for the consideration of the Prime Minister and the President. Prime Minister, after considering the panel of names, recommends one name to the President of India. A note with the recommendation is submitted to the President of India. That's how the system works. The Election Commission of India, as it is now functional, is fully independent. It acts entirely in terms of the relevant statutes relating to election and ensures the integrity of the electoral process. Once the electoral process is set in motion, every aspect of the process is regulated by law and is not amenable to any intervention by any external agency. The Election Commission of India enjoys a great amount of international reputation with regards to its role in the conduct of elections in India. I place and record a series of MOUs with the Election Commission of India has entered into. There is a UN model, then based on the model, both 33 countries have entered into MOUs. At the cost of repetition, it is submitted that it would be too wide of the mark to compare the fact situation beneath Narayan and conclusion drawn therein with the instant case. Comparisons merely on the basis of considerations of anxieties expressed regarding insulation of criminal investigative agencies will be inappropriate. The position of obtaining of the 1991 Act shows the Election Commission is independent in all respects and time-tested convention as regard the appointment of election commissioners and the elevation of chief election commissioner are in place without any room for complaints regarding independence being compromised. Therefore, submitted there is no room whatsoever for a second look at other models of schemes obtained elsewhere. It is submitted that only in case of demonstrated circumstance of fundamental rights infringements can there be an imperative for judicial intervention for enabling, facilitating, or effectuating fundamental rights. This case presents no such urgency or imperative. General debates touching upon constitutional changes or proposition, howsoever desirable, deserve to be relegated to other domains of discourse. Before I proceed further on showing some judgments in
Mr. Attorney, let us see the Act of 91, how it demonstrates a reference to appointment.
Yes, Your Honor.
Because I don't find anywhere regarding the mechanism in appointment.
No, it is not here.
Then
I'm not saying it's here. Nobody says it's here.
your statement is, read this paragraph.
I said that's a convention.
No.
That's a
Sorry.
convention.
Please, paragraph 10 of this letter which you give to us.
Your Lordship.
Read it.
That's right.
What kind of independence you're asking in 91 Act? There's nothing.
No, the
91 Act only deals with what will be their term, what will be their pay structure, what will be their pension. That's all.
Then the question would
We are on the entry level. We are not at the level as to what will be the term and conditions of his service after he is inducted.
Wait, right.
We are referring to how the induction has to take place. That has
see
nothing
the
to do with
question.
that
I see the question. The point would then be, then the 1991 Act does not touch this subject.
Correct.
Right. If it doesn't touch the subject, the 1991 Act is unconstitutional.
No.
It affects the independence of election commission. Therefore, something which is outside. To say, either we say the 1991 Act is silent on the subject, and because of its silence,
shows from
and
91 Act.
because of its silence, there is.
We shows from the Act of 91.
Yeah,
What is the mechanism in place for the purpose of
Nobody
appointment? You don't
says the 91 Act contains that mechanism. That is
what kind of independence you're asking for in 91 Act? 91 Act only says term of appointment will be this, salary will be this, pension will be this. That's all.
No, let me come back to that. What are those aspects which will qualify as independence of an institution? We must look at them. That's why I said in the beginning, tenure, remuneration, and maybe any other second, third, fourth additional factor. So if the 1991 Act does not address those second, third, or fourth additional aspects, the Act may be found to be wanting. But to say because there is a position obtaining outside the Act will not be in conformity with the independence of the institution, maybe yet another step. So therefore, we are not looking at the inadequacies of this law, unless the court had to say, oh, the law should have addressed that also. That's precisely what we're now talking about, in a different way, in an indirect way. We are saying,
We are not saying that.
No.
We are saying none of the statutory instruments lay down that procedure.
Your Lordship, please.
We are kind of looking at the manner in which you are appointing and whether the manner of that appointment
Inspires confidence.
can put in a person
Correct.
in that post who can act or who would be an independent person.
How do we really test that proposition? Either the court says on an analysis, on a demonstrated basis of faults, crevices, then comes, look here, whether it's not part of the law or not, it does not make a difference. Your practice, your experience shows us that you are we are now not looking at the law. We are now going back to a stage where we have a series of recommendations which said there must be a consultation process. There must be this, etc. Suggestions are given. Inclusion of some dignitaries would be high placed and would be probably make a difference. There are all those propositions and good suggestions. So the 1991 Act, which came after Goswami's report, has probably kept them aside, let's say, for whatever reason. Or thereafter, Parliament, that was the early occasion when Goswami report was taken into account, Parliament applied its mind. And thereafter, if the Parliament or the government did not find that the reason to depart from a convention which is being followed, and which according to the executive and the Parliament could have doubted it. At no point of time, any doubts regarding the convention or the practice have been raised either in the Parliament saying, look, what are you doing? We have now reports and information to have a debate on this issue. So we find the convention is not convincing at all. We must depart from that convention. So we don't have any one of those situations which may warrant or a trigger, I said, a relook into the whole issue.
Yes.
So there is a convention which is certainly not part of the law, but it's a convention. So there are lots of conventions which enter into decision-making process at several institutional levels, including appointment of the judges. So there is, for instance, several matters settled inside, on a certain understanding of, how. Therefore, one need not get into all those things.
So the convention is that there are convention and that too time-tested convention.
That's right. That is
the convention.
Just
Whether there is any memorandum of procedure which you're following. My
Internal
brother
arrangement,
also asked that question.
That's right.
There is no material. I mean,
That's
they're
right.
basically following the rules of business. The matter is placed before the president and the prime minister. Notice prepared, cabinet decides it, and is appointed.
So there is
That
the Lordship's note. I think in certain areas of institutional governance, a certain element of informality will always be necessary. And as many rules and guidelines you stuff into the institution governance, there can be problems. So the informality is a very important process. But under the guise of informality, there should not be a scope for an abuse. That's all. That's the only bottom line.
All right.
That's the only bottom line. And if that is not perceived, then perhaps the court would say hands off.
Now, what do you say about the other argument that to insulate the CEC from financial vulnerability, you need to have, and also staff, that it should have a secretary. Is that not a matter where, because we are discussing, it's all very well for us to discuss independence.
Right.
So true independence will come only when they have the wherewithal in terms of staff, materials, finance, to carry out their daunting task. So what do you say about that? What is standing in the way of, giving them, like Sheshan said, that 1.5 lakhs for a, for a candidate. We have, of course, gone past that stage.
No.
But
These
it's a matter, I think, where which you should not be.
I don't have many things to say on that, but as long as the election commission has said something on that subject, and I'm sure that must receive a weighty consideration with the government. I don't think, but I won't be in a position to offer any comments on it. But institution will serve better if it has all the necessary infrastructure.
Autonomy.
A court without, for instance, today in the digital age, a VS physical space is not a court. Understand all that. So therefore, infrastructure. But then the question of shifting to from a charge fund to a consolidated fund and then bringing up all those things will be a matter for again a serious parliament, because consolidated fund, what would constitute, what would be charge fund, they're all basic part of a constitutional framework.
The matter of policy about that.
So
then what about extending the irremovability clause to the election commissioners, which is another argument which you have raised. Now the chief election commissioner alone cannot be. Now we have a different scenario also, because now you admit now the journey of the chief election commissioner marks its beginning as an election commissioner. So the election commissioners have become perhaps as equal after the Sessions case also, that they have become a permanent sort of structure now. Because you had that 90,
right.
First you
Right.
brought out the notification, then threw it out, then now it has come to stay.
Right.
Now it is a multi-team,
That's right.
multi-member. So the election commissioners are as important, because they what the reasoning of
As the chief election.
that's right. So Justice Ahmadi's reasoning in the other case was the tenure, because it's actually got to do with the tenure. Because no election commissioner can say that he will have a right to, particular period. I mean, in the sense that if any, election commissioners, if any. But now that if any is gone.
Gone. That's gone.
It is gone now.
That's gone. And for good.
It's gone for good.
That's right.
Because you are saying it's seniority.
That's right.
That is so. Why not apply the same principle that they can't be impeached, because they are doing the same job as a chief election commissioner.
They can't be.
Secondly, they are in line for becoming CEC. So all these reasons put together should not they be conferred, clothed with that kind of protection? Is the argument.
I slightly digressing.
In fact, writ petition civil 1043 2017. My petition and Gopal is arguing.
Mr. Upadhyay,
Yes, madam.
I have some
without your robe and
the
band.
petition.
No, I'm not arguing. In fact, Gopal is in other court. Other Gopal is
As a
arguing.
client, if you come.
Let him argue.
I didn't want
Yes,
to get
specific
any
details.
adversarial
That's
contest
right.
here. That's why. So it's at a different level, but
Yeah.
I may have something to say about the contents of the. You'll also know the famous Brandeis brief. Yes, Louis Brandeis and Mullen versus Oregon, that famous case where Brandeis prepared a brief in support of a
Social.
that's right. Weekly, they support working hours for women. But then
Have to be given.
you lost. It went into 100 pages, only 2 pages devoted to legal arguments, 100 pages of scientific material,
That worked actually.
etc. Therefore, which added later, even though this was refuted in its scientific accuracy, different question. So we must have a credible set of information, in fact,
That's right.
on a petition like this. Therefore, I have something to say on how.
But then what do you say about this aspect alone? This is
Illogical.
what we wanted to know.
Yes.
that the election commissioner should also be given the same protection. Is what
Yeah, I'll try this one. What do you want to say?
provided further. So that argument is based on provided further. You just wanted you to address is that. I think that should be the. We have to move on anyway. We never get.
Yes, Lordship, let me just take your Lordship to few paragraphs in TN Station's case, and then it's in volume 3.
So that, Balbir can take over now because. Yes.
You want.
Just, one is, I think a lot of answers are there in 324 itself.
Authority is complete.
No, no.
Whichever way, it's between you both, I guess.
No, we had a good combination.
So, of course, I support whatever.
We have concluded, we want to know because we have to just.
I know. I'll just do. I also thought I will not read out all the judgments in Excel.
Don't please.
We have prepared a note.
Just give us those paragraphs.
We have prepared a note where relevant paragraphs are
That is it.
very handy for a lot.
Please.
We have prepared it. I don't read out extensive paragraph.
Don't do.
We don't. So just only this paragraph from TN session, page 1522 of that volume 3,
Paragraph of that.
paragraph 11, 1522. And then turning over to page 1523, within 1522 paragraph 11, just after placitum F, there's a sentence beginning. These have undergone a change after the ordinance which was so amended the act as to place them on par. However, the proviso to clause 4 of Article 324 says the CEC shall not be removed from his office except in like manner and in the like grounds the judge of the Supreme Court. And the conditions of service of CEC shall not be varied unto his disadvantage after his appointment. These two limitations in the power of Parliament are intended to protect the independence of CEC from political and executive interference. In the case of ECs as well as RC, the second proviso provided they shall not be removed from office except on recommendation of CEC. It may also be noted that while under clause 4 appointments of the consultation election commission is necessary, there is no such requirement in the case of appointment of EC. The provision that ECs and RCs once appointed cannot be removed from office before the expiry tenure, except in the recommendation CEC ensures their independence. The scheme of Article 324 itself is that after insulating the CEC with the first proviso to clause 5, the ECs have been assured independence, the functioning of providing them cannot be removed except the recommendation of CEC. Of course, the recommendation of Supreme Court must be based on intelligible and cogent consideration which should have relation to the efficiency of the election commission. It is because the privilege has been conferred on CEC to ensure the ECs and RCs are not to the mercy of political and executive bosses of the day. That is where the CEC's role comes into play, not because the CEC will act whimsically. And it's necessary to realize the check and the executive part to remove is built in the second proviso to clause 5 safeguard of not only this country but the election commission body. Therefore, the power to be exercised by the CEC as per his human caprice, the CEC himself would become an instrument of oppression and would destroy the independence of the EC. And the RCs are required to function the threat of the CEC recommended removal. Therefore, that's a matter of experience. That's a matter where it is demonstrated there is something which has gone wrong in the state of Denmark. Then one more paragraph, paragraph 16 at page 1527.
Yeah. Can we note it and
1527.
paragraph 15, we.
Paragraph 16. While it is true that under the scheme of Article 324, the conditions of service and tenure of officers of all the functionaries for the election commission determined by the president unless determined by the rule law made by parliament. It's only in the case of CEC that the first proviso to cross 5 lays down, they cannot be varied to the disadvantage CEC after the appointment. Such a protection is not extended to the ECs, but to remember that by virtue of the ordinance, CEC and EC are placed in a part of the matter of salary and etc. That the absence of such a provision for ECs make the CEC superior to ECs. The second ground relates to removability. In the case of CEC, it can be removed from office in like matter, like ground, as a judge of the Supreme Court, where the ECs can be removed on the recommended CEC. That, however, is not indicia for conferring a higher status of the CEC. To so hold is to overlook the scheme of Article 324 of the Constitution. Remember, CEC intended to be permanent incumbent, therefore, in order to preserve and safeguard independence, he had to be treated differently. That's because there can be election coming to the CEC. That is not the case for the ECs. They are not intended to be permanent incumbents. Clause 2 of Article 2 suggests that a number of ECs can vary from time to time. In the very nature of things, therefore, they could not be conferred the type of irremovability that the third of the CEC. If that were to be done, the entire scheme of Article 324 would have to undergo a change.
That's it.
So, yes. Please, Judge. And this copy is for the court. So that is, you would like to read your plan. This is this.
Yes.
Yours. Excellent. So, but I hand over, I just hand over this. You hand over both this to the court, and then the High Court judge. First High Court judge, then this. I just want to place a judgment to the Andhra Pradesh High Court for a very small reason. It was in the context of that reorganization,
Paragraph.
Andhra Pradesh.
Paragraph.
In the first page, the reliefs is are set out. The Honorable Court will please issue a written order reduction in the nature of mandamus, declaring that Article 3 of the Constitution of India is violating the basic structure and the preamble of the Constitution of India, apart from inconsistent with other provisions of the Constitution of India, particularly parts of the Constitution of India, and quash and set aside the same or alternately declare the Constitutional Amendment 1955 insofar related to not ascertaining the views from the state legislature pertaining to provision proposed in draft bills in the state assembly.
What is the relevance? Why are you doing?
No, I'm just kindly turn over to paragraphs 4 and 5 and 6. Now, two propositions. One, that there cannot be a suggestion that one part of the Constitution originally enacted is in conflict with the basic structure.
That
That's right. There cannot be any suggestion like
We
that.
don't have to.
the
Right.
parent constitution, one cannot adopt.
Even the basic structure.
Yes, but Amendment Act can be.
It's always a law,
Yes.
an Article 368 law, even
That will
amending
be
the Constitution can amend the basic.
That we don't need any judgment.
So it only says that, I only want to say that in a recent context, the court has occasion to that. Because an argument that the note ultimately given by Mr. Prashant Bhushan says in the last paragraph, declare 324 that position appointment by president as unconstitutional. Therefore, if that is not to be done at all,
Obviously.
and there is going to be some other premise. Therefore, to suggest to go further and say I am saying unconstitutional because it offends the basic structure. That again is a flawed proposition.
Yes.
That is his demand. Doesn't mean that every demand is to be accepted.
Absolutely.
No, that's not even my demand.
That's how his note ends. That's how the note ends.
All right.
We have prepared a Melanchthon will try to place before your lordships. And the other is just to give this first. So go into the book. There's one title called Note 3. This is the new note on paper. You can.
What is your, yesterday we did not, at least I did not.
The lordship is.
Article 326 of the Constitution
Yes.
and the judgment of Justice Salmeshwar, the Haryana Panchayat case,
Yes.
where lordship a constitutional right. Because if you see Article 326, it speaks about every person above 18
I'm sorry.
being conferred a constitutional right to vote. Article 326.
That's
So whether it's whether the judgment in 2013 10 SCC page 1, that is in the PUCL matter,
Yes.
that's by 3 judges bench, that is not noticed.
yes.
But since we are a 5 judges combination, we may have to go into the question whether right to vote under Article 326 actually partakes of a constitutional right.
That's
What is your thing? What is your
no, and that's why I want to come back saying the 326, since it's talking about an adult suffrage issue, whether Parliament can enter into it and then add or decrease. If that's going to violate again, let's say the 18 or 21, many considerations can come up to that.
As it stands,
As it
every 18-year-old person not subject to any disqualification, which are mentioned therein.
That's true.
So you
Amendments were brought into that provision.
Correct. Subject to that, there is a constitutional right, isn't it?
That's true. The question then will be whether that amendment stands the test of a basic structure or any other fundamental right. That will be the only test again in all the
No,
circumstances.
what's your argument as to whether it's a statutory right or a constitutional right? Because it actually partakes of 3 rights. One is it's a legal right under the statute, following the constitutional right under Article 326.
Right.
Thirdly, it also has features of fundamental right under 1920. So there are 3 aspects to it.
I understand that. That's why judgment referred to Lord yesterday on the stage beyond the right to vote.
That's right.
That's right. I see
So
that.
it's also a constitutional right. This is how it will have to, We have concluded, we move on to Balbir.
Yes. I just conclude.
Take 1 hour.
You know,
I hope you will not hold up.
He's ready to spring on. And I don't want to take his time. I know. So I just this. Just in these notes on judgments, and also we have a compilation of judgments. I just want to flag worships. So there is a separate compilation of judgments which is given to the court, not this one. There's
No, but are these beyond the ones already submitted?
it was
Because 3 volumes have been,
No, I think there's a
Four
compilation like this.
4 volumes.
He's on behalf of the respondent. Will just will make a note of the judgments I want to place reliance upon. Serial number 1.
What proposition are these?
Paragraph.
Broadly on the theme that, like you ought to know that a mandamus is not a right creating writ. It is only a right enforcing writ. It doesn't create rights. So on the
Mandamus is
question
court of relief.
So when there is an antecedent legal right, you will have it enforced through a mandamus.
Yes.
You don't create a right by that.
Except that continuing mandamus.
That is when a mandamus is already available. If it's already available and can be invoked, then you have a continuing mandamus.
That all the 5
That's right.
writs are
That's right.
relief.
For these judgments only go to show the limits to which a mandamus would go, and then circumstance when the court goes on to say constitution benches and 3 judges benches which says that we will not certainly go beyond this line. So all of those.
Habeas corpus may create a right. but
Habeas
not-
corpus because of
Not other four reads.
liberty.
Yes.
That's why you ought to say what freedom does this freedom have. Therefore, liberty stands on a higher footing, absolutely beyond any consideration.
Mandamus doesn't create a right.
No dispute about it.
So I only want to show how even despite the growth of a law, Nagappa said we are leaving behind all those technicalities of English administrative law. But even thereafter, the question is there will be some outer limit where you will not create a right and say the court will create a right and have it enforced too. And then
Not ignore the power available under 142. That is the final Brahmastra.
I'll just have only one word on that.
Because that is the basis for all this.
I'll have one word on that. I'll give an example and then I'll conclude. You'll also make a note of this, and the paragraphs are given here. And Ashwini Kumar and then Vivek Krishna and serial number 1, 2, 4, and 11 and 12. 1, 2, 4, 11, and 12 are important for purposes. And on 142, just one illustration, that I will conclude with that. We had a Vyapam scam in Madhya Pradesh, admissions to medical colleges. So people got into medical colleges by some illegal means and ineligible students. So by the time the matter came to the Supreme Court, many of them have completed 4 years, 4.5 years, some were in 3 years, some had gone to the residency stage. A 2-judges bench of your lordships went into the matter, and one honorable judge thought, why should a period of study undergone by a student should go a waste? It will be an economic waste for the student, also a national waste. So the learned judge thought that such students can be asked to serve for a period of 5 years in army corps, etc. And thereafter, on a completion of the tenure, they have their medical registration done. The other learned judge disagreed with that. On the disagreement matter went before a bench of 3 honorable judges. And I was assisting the court in that matter for some of the petitioners. I said, a view taken by the learned judge regarding this waste issue is a very important, very subtle but an important, promotion of a value of education. But the 3 judges did not agree with us and turned down that request. And they said Article 142 perhaps cannot be invoked, and in these circumstances also. The point I want to make is the 2 important expressions used in 142 is in a cause or a matter. To do complete justice in a cause or a matter. A cause has a certain higher connotation, namely where the law does not really address a cause. In the initial days when 142 was being used, for instance, matrimonial disputes, compounding. Section 7B of the Hindu Marriage Act would not have provided for a compounding. Therefore, for 6 months you wait, 1 year you wait. It takes a long period before the trial court. Therefore, court try to deal with that matter. But over a period of time, you then try to land into certain other areas. So the cause of a matter is a very important guideline. And if there is a cause, means something which is not addressed by the law, and that not being addressed by the law is now presented to the court, and the court must resolve it. There is a cause of national concern, importance, so on and so forth. And if there is no such cause, and if Parliament or law has addressed it, but then we reach the second stage. It has been addressed, but inadequately addressed. Then comes the question of violation of rights, so on and so forth. That's how we continue of entering into one. Otherwise, the reservoir, it is not a jurisdiction. It is a power of an authority like the inherent power in Section 151, much more than that, because we are a constitution. So these are the broad areas where 142 is looked into. And I don't think I need to take a lot longer. I hope wherever there is some shortcomings in my presentation, I hope I will be pardoned for that.
Thank you.
As Mr. Balbir Singh is just taking over, AG started by saying, referring to Justice Frankfurter, spaghetti is fine. So I was just wondering whether Justice Frankfurter was introduced to spaghetti on the dining table or in the kitchen larder. If it is in the kitchen larder, spaghetti would be very stiff. Nothing would be malleable there. Just wondering.
Thereafter, it has been referred to in.
No.
Well, if I try and draw analogy on that, is the cooking more important or cleaning more important? So you will start cleaning first and then cooking, or in today's context, should we have a cleaning first before we start cooking so far as 324 is concerned? Sorry.
Just one small final. As I said yesterday, if the court were to reach the first stage, a gap or a vacuum affecting fundamental rights, then Parliament will address into that, all that. And let the court reaches say the question of whether there is any interim measure, etc., will also not arise. That may not arise, because that will introduce need and uncertainties in a system where it is working fairly well. I just only want that.
That if my lords permit to start with where.
No, actually, you are appearing for whom?
Well, I'm appearing for the Union of India only.
You're for the Union of India.
Yes, Malad. Well, just to carry on for limited purpose of 142, for doing complete justice, that's the fundamental underlying factor of 142. So there should be apparent, visible injustice happening by delivery of something by the court. So if there is, to make complete justice or to do complete justice is where, in my respectful submission, 142, the court steps in. So therefore, there has to be an underlying foundation to see that if there is any injustice happening, that's what I'm only adding for limited purpose, Malad, where the cause and matter we look at. So that injustice is extremely important, Malad. I'll just pass on so that I remain in a discipline. I'll just pass a small note so that what are the points I'm taking forward. But what seems to be bothering my lords is that 34.2, the appointment is a point of concern. That seems to be the concern which is arising to this court. And based on that, my lords are linking it to say that the fairness and independence of functioning of a body. And my request would be, when we read 324, kindly see commission and commissioners separately for a minute. We are looking at independence of an institution. So we are looking for independence of the institution. And we are looking to appointment of commissioners for that matter, that may be CEC or EC minutes. If the mechanism provides that the institution can function independently, and so far as the appointment of the constituents of that institutions are concerned, that the constitution makers thought it fit, after deliberating what can be the pitfalls, or if I may call headache, that to what extent and till what time it should be left as it is, unchanged, unamended, and with the wisdom of Parliament, whenever they think it is right, should be done by the Parliament. And it is not that the Constituent Assembly was not conscious of the fact, and as my Lord said, that they were aware the headache is going to come, and the headache is here today. So we are dealing with that headache today, knowing fully well that there is going to be a headache 75 years down the line, that there were 2 or 3 options which were discussed or debated at that point in time, not chosen, not opted for. And the route of the leaving to law to be made by Parliament is to be left. And in the beginning, my lords asked a question: what is the meaning of the law to be framed by the Constitution? And if we see, the language is very interesting. 324.2, my lords need not specifically open, I'll say, subject to the provisions of any law made in that behalf. So some behalf, some law can be made by the Parliament. That's what the 2 says, sub-article 2 says. Now, at that point of time, either it was that it could have been plugged, and the one way of plugging was that the appointment should be with the 2/3 members of both the joint houses. That was the one option which was not taken. Second was instrument of instruction could have been there, that these are the instrument of instruction should be followed, and therefore this will safeguard the so-called attack on the independence of the institution. That also was not chosen, in spite of the fact, noting that we are not absolutely adopting the American Constitution, and we are adopting Indian with the modified, maybe instruments may be adopted or instructions may be adopted. That also was not to be done. Why in that case it is said that it is left to the Parliament, and why, unlike in 16(4)(a), where the option given, and if we see that mandamus can't be issued because that option is given to the state, if they think that the reservation is to be issued, that's a prerogative of the state. So that's a one way of 16(4)(a) kind of situation. Enables the state to do it. That's a one way. If you look at 21(a) for that matter, shall make law. So that is another way that shall make law, which is there. This is a third way to look at it, subject to the law made in that behalf, which has been said. Well, in my respectful submission, and if we try and compare the Constitution where these kind of phrases have been used, and are knowing very well there is a headache which is likely to come. In spite of that, in my respectful submission, and also coupled with the fact that at that stage it was not seen as a multiple member body, it was seen only a one person, because nobody anticipated that we'll be in election mode 24/7 at some stage maybe, and therefore we need a larger institution for that purpose. So therefore, and one more aspect was in the beginning, it was pointed out that democracy, the basic principle in the organs is a faith, that, and that's a presumption which is coming from M.S. Gill and so on and so forth thereafter, that there is a faith in the organs that everybody is going to fulfill their respective roles. That was the very fundamental and the basis of the Constitution which was framed. And that's why in my respectful submission, when it was left in this form by the president, the faith was that ultimately, because we are dealing with the parliamentary decision-making process in a democracy, the will of people should prevail. And there is a faith that the system is going to function fine. Therefore, if that headache lands at some point in time, the first preference should be given to a parliament to make a law on that part, that do we need to deal with the headache in a particular manner. And besides the fact that yesterday my lords pointed out that in last 8 years, 7 election commissioners come, or 8 years, or 7 years, 8 election commissioners come. The data which we have seen, today, when we see, since I was also not aware, there appears to be in Wikipedia either the dates of EC position has been taken or CEC position has been taken. A cumulative is not given. If we look at a cumulative number, that seems to be on a higher side than the average, which was looking that it is being changed so many times. Other than two factors which I believe is bothering my lords while looking at 324(2) is that there are multiple reports which exist, and even Election Commission itself has said, the political parties themselves have said that there is a need to reform this process, and therefore one of the possible reform can be that we come up with the appointment fairer and independent than what is being today left to the executives in the current formulas. This has already been argued that there is no underlying fact. We are not dealing with the position saying that a man of zero integrity has been appointed as EC or the CEC. That is not a question which has come. The best cases my lords have seen started from the NOAA is that whether the ECs are in line with the CEC and CEC agreeing with them or not, notification issues, withdrawn, cost abolished, all those factors. So that is more to do with the internal functioning of the institution, which is not under challenge. Today, everybody agrees on this aspect that institution has worked perfectly fine. The most important part in democratic process is timely election of the election to be conducted. That's the first fundamental part. Second is the participation of people who are willing to participate. On both counts, there is not even a single allegation that by virtue of election not being conducted on time, the existing ruling party is going beyond the period of 5 years, and therefore they're still retaining the power. That kind of anarchy is not being pointed out. Second is, it's also not a case, somebody saying that we had 297 million of the eligible voters in the last election, 67% voted, but 5% were not allowed to be voted. So therefore, it is not case there is a
democratic process in participating in the forming the parliament has not been carried out. On both the factors, there is no allegation on this aspect. And why I am pointing this out is, with all humility, that 3-4 cases which we have seen where the court have intervened and laid down certain kind of a guidelines, or I would call guidance, because it is for the time being, the law is not being framed. All those 3 cases are where the union was ad item, and it was more in line with Article 21 kind of position, which is much higher in terms of liberty and life. And there was some trigger point always. Even if we go for the judgment in Vishaka, the rape in Rajasthan was the start point where this debate started. And then the further debate happened, the international conventions were there. So therefore, there was a background material knowledge.
Not adversarial, actually.
That not adversarial knowledge. And today, if I may not be right to say that it is absolutely zero adversarial position. Today, there is a process which is functioning. And what is there in my Lord's mind, looking at, appears to be that seems to be some anomaly in 324 so far as the independence is concerned. What we do in that case? I asked myself a question saying that by virtue of providing an alternate arrangement with whatever that arrangement would be, a composition of CJI, Prime Minister, Leader of Opposition, are we going to dislodge President from 324.1 and 324.2? In my respectful submission, the President cannot be dislodged. If the President cannot be dislodged, are we going to dislodge the aid and advice of the Parliament or the Council of Ministers? Are we going to dislodge that? If we are not going to dislodge that, then what do we gain? Are we trying to create a recommendatory body which is going to recommend to Prime Minister, to the President, and President ultimately has got the aid and advice available? Then we are back to square one. Or we are saying that we dislodge President, and this body is going to function, and this body is going to get into the appointments of the CEC and EC for that matter. And I presume my lords are certainly not looking at lawmaking. I've understood, so therefore I'm not laboring on that. That there is no intent to dislodge the President out of the current situation, and not the aid and advice as well. So where are we heading to when we look at what the solution? So that's the one thing which I wanted to park before my lords, to see that what are we trying to achieve. In the underlying fact, there is no real basis to say that 2 very important factors of the parliamentary democracy, which is to be performed by the Election Commission, has not been carried out. There's no allegation of that nature. So looking at it from that point of view, my lords, bear this in mind. Where do we draw a parallel of this nature? And the reliance was on NJEC case. And there was interestingly a discussion on the role and functioning of Election Commission there also. There was a discussion on the role of committee reports also, which were in the favor of NJEC, and my lords looked into that part. There was also an examination of parliamentary debate, that how parliamentary debates are to be looked into. And after that, looking at everything, Justice Madan Lokur in one para finally said that the appointment of judges and Election Commission is completely different. So you can't equate, and the reason seems to be not far in my mind. This process is amenable to judicial review. A decision by this court or the process of appointment of judges is not amenable to a judicial review. That's a very, very important fundamental factor. Before I move forward, 3-4 paras I want to read, and those are going to be clincher in my respectful submission, because that has been considered in NJEC. This is 2016, I pass on the book.
Yes, 2016.
I'll just give the 2016 5 SEC, page 1. If my lords can kindly come to page 242, para 27. There are a few paras are going to be very relevant.
Page 242, para
27.
27.
27. May I please?
The learned Attorney General also referred to Article 145, whereunder it was open to Parliament to enact law framed by Parliament for regulating generally the practice and procedure of the Supreme Court. In the absence of any such law, Supreme Court had liberty to make rules for regulating the practice and procedure of the court with the approval of the President. It was submitted that even on elementary issues like procedure, Parliament and or President assigned the role of the Constitution activities strictly in the judicial domain, even to the extent of that. Now, kindly, role of Election Commission, there is a one para 44 on page 253. On page 253, para 44. In the like manner, our attention was drawn to part 15 of the Constitution pertaining to elections. It was submitted that Article 324 vested the superintendent direction and control of elections to Parliament and the legislature of every state, and election of the office of President, Vice President with the Election Commission. The Election Commission, in terms of Article 324(2), was comprised of the Chief Election Commissioner and such number of other election commissioners as the President may from time to time fix. It was submitted that the appointment of the Chief Election Commissioner and the other election commissioner was to be made by the President, was subject to the provision of law made by the Parliament. It was further pointed out that under Article 324(5), the condition of service and the tenure of the office of the Election Commissioner and the regional commissioners is regulated in the manner as the President may by rules determine. Of course, subject to the enactment of law by Parliament, so as to depict similarity with the matter under consideration, it was contended that the proviso under Article 324(5) was explicit to the effect that the Chief Election Commissioner could not be removed from his office except in like manner and on like ground as a judge of the Supreme Court, and in furthermore, that the condition of service of Chief Election Commissioner could not be varied to his disadvantage after his appointment. It was contended that the Indian experience had been that the Chief Election Commissioner and the other election commissioner had functioned with absolute independence and that their functioning remains unaffected despite the fact that their appointment has been made by the executive. It was submitted that the impartiality and independence emerged from the protection of the condition of services of the incumbent after his appointment and not by the method or manner of his appointment. That was the argument which was raised. And way the appointment of judges. This was a parallel which was shown. Now, kindly see, the para 45 also may be relevant to some extent. Only not, I'll not read the case on Bharati, but 45 sees it was also the contention of the learned Attorney General that implicit in the scheme of the Constitution was a system of checks and balances, wherein the different constitutional functionaries participate in various processes of selection, appointment, etc., so as to ensure the constitutional functionary did not exceed the function and responsibility assigned to them. I'm purely reading on limited purpose, checks and balances. There are existing checks and balances. Let's now kindly come to page 4, para 456, which is available at page 490. 490. And interestingly, in this case also, while debating on the appointment of judges, instrument of instruction was discussed. Page 456, page 490, para 456.
Yeah.
After a few months, on 11/10/49, the President of the Constituent Assembly was informed by Mr. T.T. Krishnamachari that Schedule 3A is not being moved and that it could not be taken out of the list. He also moved for the deletion of the Schedule 4 from the draft Constitution, explaining the move to delete Schedule 4 from the draft Constitution. It was stated that the matter should be left entirely to the convention rather than to put in a body of the Constitution as a schedule in the shape of instrument of instruction, and that there is a fairly large volume of opinion which in favor. In that case also, it was specifically pointed out that there can be instrument, but that was not provided, except that what we see in 124 today. And this portion is reproduced, which starts with the debate on the instrument of instruction, which has been done in this case also, not followed those in today's time also. Then, my lords, actually come to para 579. I'm just showing page 539 and para 579. 539. Extensive reports were there I'm just pointing out one or two, my lords.
539.
Page 539, para 579.
Yeah.
Be that as it may, NCRWC submitted its report to the Prime Minister on 31/3/2002. In Chapter 7 of the report relating to the judiciary, NCRWC recommended in para 7.3.7, therefore, establishment of a NJAC. It was observed that such a commission was necessary for the effective participation of both executive and the judicial wings of the state as it integrated scheme the machinery for appointment of judges. I'm not reading other reports on this, so I'm just pointing out there were multiple reports which were suggesting that there should be a participation of the executives on this part. Now, let's kindly come to paragraph 647, which is available at page 567. Paragraph 647,
At page
567.
56.
Yes, 567 and para is 647.
Okay.
This is regarding the assembly debates. What's the role of the assembly debates?
That's right.
It is quite clear that the overwhelming view of the various learned judges in different decisions rendered by this court and in other jurisdictions as well is that, point 1, a reference may be made to the CAD or the parliamentary debates, which is referred as a relevant material, to understand the context in which the constitutional or statutory provisions were framed and to gather the intent of the lawmakers, but only if there is ambiguity or uncertainty or incongruity or obscurity in the language of provision. A reference to CAD or the parliamentary debates ought not to be made only because they are there. 6.447.2 minutes. CAD or parliamentary debates ought not to be relied upon to interpret the provision of the constitution or the statute if there is no ambiguity in the language used. These provisions ought to be interpreted independently, or at least if reference is made to CAD or parliamentary debates, the court should not be unduly influenced by the speeches made. Confirmation of the interpretation may be sought from the CAD or parliamentary debate, not for vice versa. So, today when we look at the debate which were there, knowing fully well there is a headache. So therefore, one option was that headache could have been taken care to straight away say that you shall make law. End of the matter, Parliament would have made law and we all would have been grappling with that law instead of dealing with the constitution per se. Now, let's kindly see now para 772 now. And this is by Justice Lokut 772. On page 613, I'm sorry.
Yes.
Similarly, that's how it starts.
Yes.
Page 613. Similarly, the appointment of chief election commissioners and the election commissioner under Article 324 of the Constitution does not require the president to consult anybody, even though free and fair elections are undoubtedly vital to our democracy. Since the consultation provisions were incorporated only for the appointment of judges, surely the Constitutional Assembly had good reason for making this distinction. Justice Keher has referred to other presidential appointments in his draft judgment, and it is not necessary to repeat them. What is important is the message sought to be conveyed by the Constituent Assembly and the sanctity given to a recommendation by the Chief Justice of India for the appointment of judges of the Supreme Court. When we look at the theme which has gone so far as looking at the approach toward the independence of judiciary vis-a-vis
Purely obiter.
I completely. I'm borrowing for the persuasion.
On a light-hearted note.
Yes,
Justice Lokur, after his retirement,
I am conscious of that, and that's what the start.
headed a committee and which has given a report where there is an article written about the abuse in the matter of appointment. We hope you are aware of that.
Because I'm aware, and that was the start point, which was raised in the beginning itself, saying that Justice Madan Lokur has raised this. All I'm saying is that when we have a comparative provisions, and this is only for the purpose of persuading my lords, that it is not that the differentiation of the two processes so far as the independence of judiciary was not examined. It was examined, but certainly that was the core point for examination which was there. The role of assembly debates were considered, role of the committees were considered, and contrary to those role and report of the committee, the language of the 124 was relied upon to say the consultation. What is the meaning of a consultation? where the Chief Justice has got the power, the entire power left with him by virtue of that, and therefore that's there. Now, in light of this, let's kindly come to 324 for a minute. Article 324. And I'm pointing out that we are segregating the independence of the commission versus the appointment of individuals.
Was not Article 142 also involved in the judge's case? Was not 142 drawn upon by the court, by this court?
Yes.
Because it's put in place a lot of direction, including the third case.
Yes.
Various procedures which completely an elaboration which is not justified with the text of the constitution.
Please, Manoj.
Entirely a contribution by the court.
Yes, in all three judges over a period of time.
Conditions as they found it in this court.
Yes.
To make provision for appointment of judges.
Yes, Manoj.
So is that not a case where, like the earlier case law, if you really go back to the first case of adoption,
yes, Manoj.
by this is Bhagwati,
yes,
by foreigners, that is how it started.
That's how it started. Yes, Manoj.
It's all referred to in the CBI case.
Yes.
Union Carbide, the Chief Judicial
Magistrate case. Yes.
From Ahmedabad. All those were cases which perhaps it may not fit in with our situation.
Yes.
But the judge's case appears to be a guiding factor from which we can draw inspiration, and perhaps if we are otherwise inclined to take it forward,
please
apply it in the facts of the case. Otherwise, you are right. Because other all cases where there was no material.
Let me add that it's surprising, but the Supreme Court invoked Article 142 only on about 9 instances till 1996. 9 instances.
And thereafter,
after that, it's
flooding.
Open the flood.
Because of all these 13B.
Yes, because of these.
Well, coming to I try to answer that how do we differentiate this position which has been taken? In 124, there is clearly a consultation which has gone to the interpretation. All I'm saying is that in 324, do we need to go down to that level to see that 324(2), when the institutional functioning is not in dispute, appointment of one man may be very relevant man and equivalent to an institution in certain situation, may not be today because we have multiple body which is there, is brought down to a level to say that because your appointment mechanism of a particular individual is, let's say, opaque and it is not visible, your institution may be functioning fine, your elections are conducted on time, there's a representation of people which is required for forming the government. Should we get into that part or not? Let's see. And that's my endeavor, is that first point which I'm pointing out, is there is a gap, is there is a vacuum. We are looking at it's not a case an individual has come to the court or an individual appointment is under challenge. The functioning of the institution is under challenge. And functioning of the institution in 344(2) is one of the aspects of appointment is election commission. That can be, my lords, I've seen that they try to stitch with 19(1)(a) and therefore a person going to vote. And so I can understand that part. But should it be taken to this extent to say that a one person who's the part of the institution which is functioning fine, his appointment we need to set to the core? When the parliament in last 75 years thought it not, I'll not say fit, but not maybe desirable. So the desirability test or utopian approach to say we want to set a perfect system should, in my respectful submission, this court should go to that extent to say that we want to set up that partners. But if we go further down, there's a guidance in this. We look at 322(4) for a minute. It says before each journal election of the house, each journal. So there is some decision making before each, and that's why today it may be by virtue of the nature of activity which has the election has shaped into, it has changed. But the constitution still recognizes that each election is a separate feature. You may be needing one election commission EC, or you may be needing 5. So the equating it with the CEC to say, should in absence, rather in the presence of 324(2), should it be taken to that level? And in my respectful submission, this was the background in TN session, where in spite that there is an amendment later on made in 1990, still the court chose to say that removability cannot be equated to the extent with the Chief Election Commissioner. That's what the para very clearly says, that irremovability is given equivalent to the judge of this honorable court only to one person. And the reason for that seems to be is, today we are contemplating that we have understood the entire election process in the country. We don't know what the 100 years down the going to be, Malaz. And this is a living document. We have to live it with it. These multiple courts are going to be interpreted. On the face of it, 324(4) gives a suggestion that before each general election to the House of the People or to the Legislative Assembly of each state, and before the first general election and thereafter, before each biennial election of the Legislative Council of each state having such council, the president may also appoint after consultation with CECs. This liberty is taken away the moment somebody is fixated for 6 years period. Somebody can make a claim, he can be removed, which has happened to notification which been taken away saying they remove the post.
Exactly what we were about to ask you.
Yes.
Can you tomorrow undo the notifications of 93?
Yes.
By which 2 posts of election commissioners were created, against which one was Mr. Gill was appointed and another was
yes.
Can you today do that in law? In law, can you do that? You can remove, you can say, you don't need the election commissioners anyway, you go back to the old system.
Please,
of having one chief election commissioner.
Please,
you can do that in law.
In law, yes, and that has come, and I'm so grateful. That's where the judicial review comes in. My lords examined this position
and did not accept it in the case of Dhanua.
Yes, and
in the case of Dhanua,
yes,
Dhanua came with the same complaint.
Yes, Dhanua came
the
with
man was working as chief secretary or
of a state, and my period has gone.
Service commission, and he came to this court complaining, I was here for less than 3 months.
Yes,
and because of the chief election commissioner, Perishastri.
Yes,
he had a problem with him, respond number 2.
Yes,
and then they were removed.
They were, yes.
The court went into it, and the court said that actually you are the problem. The election commissioners were the problem because they were having a constant rift with the chief election commissioner and throw their petition.
Well, it's like a cricket team.
So subsequently, when Sheshan took over in December 1990,
yes,
the midst of his term, you bring in this two
more.
So thereafter, this has come to stay.
Yes,
now we have election commissioners, a multi-member team.
Member body.
But even that can be undone by you in law because it's not part of the constitution.
Yes, it's correct. The president can issue a notification.
Isn't removing the posts?
Yes,
you can remove the posts.
Well, that's where the difference between the appointment of judges and appointment of election commissioners, because that can be tested, and as a matter of fact has been tested. Finally, whatever. Well, my lord said it's a man of character. Ultimately, we are looking for. The appointment process can take a person to a position of CEC or EC. How their interplay role between the parties, that the appointment process is not good to. We get the best batsman in the team. 2 best batsmen fighting each other because somebody wants to open the inning and somebody wants to get to the second down. They'll fight because they're equally powerful in the team structure. So therefore, they'll always fight. That's a test of a human aspect, that who has got what kind of a qualities in that. But that has nothing to do so far as the appointment process is concerned. Appointment process, we were briefed, Malaj, and we were discussing with the learned attorney general whether the existing structure, the manner in which the elections commission, the elections are being conducted by this body, how much role of manipulation is there? How much role? And that's the reason why this has not happened, Malaj. We can see government after government which has been coming and going. And in fact, after these the electronic voting machines which have come, it would have been the easiest way to manipulate. If somebody would have zero complaint, nobody, not even the opposition parties, losers have ever complained, barring certain instances which have been there. But the system, I've been told, the system is of such magnitude that it doesn't allow somebody to be partisan to an extent to say that it's going to change the formation or going to affect the electoral voting to be compromised in some sense. The whole mechanism doesn't permit that somebody can go rogue. The system, and that's why we are talking of a independence of the institution, and we are not talking independence of the individual. The individual appointment.
Supposing the election commissioner is asked to take on none less than the prime minister himself.
Please.
Giving an example.
Yes.
Just an example.
We are testing this.
Hypothetical example. Supposing the election commissioner sort of, is so weak-kneed.
Yes.
that he says, okay, I carries with it, he doesn't get around to doing it. Will it not be a case of complete breakdown of the system then? I'll just give you an example.
Yes, honestly.
The reason being that he's a man who's supposed to be completely insulated.
Yes,
And when you talked about character,
yes,
character consists of various components.
various components.
Like integrity,
Yes.
honesty. But one particular characteristic required is independence.
Well, certainly, yes.
The independence is, like you said, we don't care. One of your election commissioners, in fact, resigned.
Yes,
You don't want to go there.
yes, Police.
So these are the aspects which perhaps the participation of a larger body
Yes,
instead of the cabinet, which always, as we know, it's only self-serving because it's natural.
yes,
They would like to perpetuate themselves in power. Any party,
please,
I'm
no.
not saying all
Yes.
parties will have that.
Yes,
Once
all
they-
parties, irrespective. Yes,
Irrespective of the political color.
yes,
That is why from 1990, committee after committee after committee keeps reporting. There is a dire need for change. Political parties, leaders keep shouting from the rooftops. But on the ground, nothing will happen.
well, interestingly, I'll come to the committee part also because there is some examination. I've seen these committee reports closely. Simple example I'll give. My lords asked a question in the morning saying that why you are still voting the expenditure and not charging it to Consolidated Fund of India. The report we read clearly say no need. In the same page, on the same page we were reading, the last para on that say, no, this is fine. It's expenditure through voting is fine. One report saying this. So what is in parliamentary democratic process where the functioning of administration has been given to our various ministries, it is extremely important that these are to be evolved with the period of time. These are to be reformed or improved over a period of time. How do we do it? We acquire more knowledge, we acquire more minds to apply to it, and that's how we create these committees. When we look at a law commission, there are the functioning, and why do we go far? This court has got a, if I say, foolproof system so far as the appointment of judges are concerned. But there are stray instances where things go wrong, which come to the knowledge. The whole idea is, should we change this to an extent to find that there are stray instances which are happening? And I'm not saying this can't happen. This can happen. And second, the best of the appointment, whether that is going to set right the system inter, say, the participant or constituents of a body like this court also. Doesn't guarantee that. But all we are trying to do is to safeguard the position. And my endeavor is, when I'm particularly pointing this out as well, the appointment of a member of this commission, how important is to be considered to say that we're going to dislodge a president. If we are not dislodging, then we are going to the same position to be done. And in my respectful submission, 324 is a vacuum of the extent. How much we should look into our transparency. Is there an extent we measure? Is we measure the extent of our independence we are looking at? Well, even if somebody by any route has been appointed and government is going to be one of the participators in that whole functioning, is it going to completely eradicate so far the relationship is concerned? I'm sorry.
One thing. The test denominator has changed from time to time.
Certainly.
We learn by experience.
I'm grateful, yes.
Let us talk about the judiciary in the first instance.
Yes.
There was a time when the selections were made at the literal level, just on the request being made by the Chief Justice of the state to a lawyer, please join.
Please,
And on his request, the appointments were made, no selection process.
please.
That also worked very
Was
well.
one of, yes.
And we find the finest of the persons who have gone and they came to this court. One system.
Yes, certainly.
But the very system, at a later point of time, started a question mark.
Yes.
Then we thought, no,
Yes.
this system will not work. Let us introduce a new mechanism, which is fair, open, and available for the public also, to know what kind of a mechanism is on place.
Yes.
We changed it.
Yes.
So that system introduced.
Yes.
Now we find that system is also not working.
Possibly, yes.
Question is, so what we change ourselves? Same is the question here also.
Yes.
If you go in service jurisprudence,
Yes.
there was a time when the appointments were made purely on interview.
Yes.
Purely on interview.
Yes.
And never questioned.
Yes.
But later the time came that this court also intervened and the judicial verdicts came forward that no, curtail the interview.
Yes.
The decision came because the experience shows that whenever the discretion is being vested with authorities,
Yes.
it is by and large not being used for the purpose.
Yes.
It being. We changed the
Change the
we
system.
said no.
Yes.
curtail the interview criteria and bring it to 15%, 12%, whatever according to the
Yes.
need and requirement. 100% interview is gone, almost gone.
Yes.
So we learn by experience.
Yes.
Same thing we put to them also.
Yes.
If the very mechanism being followed for last 70 years, it's 69 years, whatever you call it.
Yes.
Where was the occasion for the petitions to be filed and calling upon the court to intervene?
Yes.
They were also silent. Ground realities are different.
Well, yes.
What we think is, and what we tell you one thing,
Please, Manas.
we only want one thing, subject to what you say.
Please, Manas.
We are not saying the system is not correct.
Please, Manas.
We are not saying that the attorney said there is no trigger point.
Please, Manas.
We don't want that the trigger point should come, then only this court should move.
Certainly, Manas.
What we think is, we want is,
Yes.
there should be a transparent mechanism
Yes.
which to avoid all kind of reasons and complaints.
Please, Manas.
And people should know for whom we are going to work
Please, Manas.
in upholding the democracy which we are.
Please, Manas.
What kind of a mechanism you can put in place?
Please, Manas.
People are not going to question mark.
Please, Manas.
You say, no, we have a council of ministers, they advise the president, appointments are made.
Please, Manas.
Everything goes inside.
Please, Manas.
Now, we put to you also the same proposition. Show us what mechanism you adopted
Please, Manas.
in making the appointment day before 2 days before.
Please, Manas.
What is your mechanism of appointment?
What is the?
If somebody asks to ask, you say it's all right. Somebody can question it, will come forward.
Please, Manas.
Why should we grant you that liberty? Why can't we take a call? Yesterday we put to you. Have you brought any mechanism? Have you brought any mechanism in place in reference to which the appointment 2 days before have you made? Show us.
Right.
Or the same council of ministers and the president and goes on.
Manas, I'll answer the attorney and.
No, you are here.
Manas, I'll certainly, but since the instructors were there on this specific aspect.
Apart from instruction, are we saying that there is an underlying unease about the accountability of the Council of Ministers and the cabinet?
They are not.
Yes, that's what even
We are not.
underlying.
Sorry, you don't understand this. They are not.
I just
We
want.
just want to know from you.
Yes.
We just want to know from our satisfaction.
Yes.
Let us know the mechanism you adopted.
I've told you, it's on the basis of a certain convention. There is a panel prepared, there's a DO to prepare. I've said so in my notes.
Which
Therefore,
one?
there is a procedure which is being followed.
Mr.
Right.
Attorney,
Therefore, there is
ask you,
one more aspect I want to make.
Mr. Attorney, when the matter was taken up, Mr. Prashant made a mention.
Accusations can come from anywhere.
They're not saying accusation. Don't take it up.
Are we following?
We yesterday put this
Following
question to you.
established procedure, or is there a departure?
Attorney, you put a question to you.
Yes.
And our request. For our satisfaction,
Your Lordship,
show us the mechanism you adopted in making appointment 2 days before.
Your Lordship, the note which I've given, which in the saying
Let us,
that how on the basis of seniority, on the basis of a panel, and
election
on the basis
commissioner
of
is not on seniority. Chief election commissioner according to his own seniority.
not only even election commissioners are appointments on the basis of their seniority in the civil service. That's how I showed that. You cannot
Our
see that
information is that
paragraph.
the
Please
gentleman who has
don't-
been
You
appointed
can flag off anything you
on
want. but Don't do that.
Saturday, he took VRS the previous day on Friday in order to be appointed election commissioner on Saturday. This is how.
The office was vacant till since May. You're forgetting that. Since May.
Show us your notes that election
No, in
commission
the-
is also
in the-
appointed
in
by seniority.
in this note itself, I've said this is the order of their seniority,
Yes,
shows
yeah.
how they are appointed. But it is not a pick and choose at all. It's all every successive election commission is the basis of their seniority.
No, we
The civil service.
as we understood
Yeah,
that
this also,
statement,
this also, and in my note.
as we understood,
Yeah.
let me clarify. We understood that the chief election commissioner is appointed amongst the election commissioner who is senior. This is
Even
what you said.
the election commissioner, your lordship, the date of birth indicates that, for instance, Mr. Krishnamurthi's date of birth is 1940.
Your request is, are you aware how much is the civil servant according to your seniority working in the ministry of central ministry? That can't seniority can't work.
Whether that would be a matter for concern or an aberration, I don't know whether that would be, because then there'll be no system can work. So there has to be some system where certain premises, certain fundamentals are said to be important. and
No,
relevant.
that you understood that CEC is appointed on the seniority of the election commissioner. You're right. We agree with you.
Yeah.
Subject to something comes otherwise.
Yes, yes.
We're talking about the entry level as EC.
I am talking about the entry level also. This gives you an indication. The entry level is also on the basis of a senior.
So we can take Seniority of whom? Seniority civil servant.
In the civil servant, there is a certain element of seniority. They prepare.
From where you get this guidance that only civil servants are the only persons to be considered in the role of
The parliament does not say beyond civil servants, you have a system or a selection, a panel or a pool.
Why you are confined to civil servants?
That's why we're entering into an entirely different debate. Whom should you pick up is the question. Are we entering into the debate? If there is a convention which picks up from civil servants because of their experience involved in administration and all that, then we must depart from the system. We will have a national pool of talents that are available. Let us pick up in the national pool of talents. That is a complete departure from the convention. Unless, therefore, I said, if the convention is found to be wrong, then you're looking at where all we can pick up people will be eligible to hold an independent office. That's a very larger debate. Very larger debate. And I want to bring up 74 section, Article 74 for a minute, Lord's kind consideration. There's an inbuilt I think, protection available there. Article 74 reads like this: there shall be a council of ministers with the Prime Minister at the head of to aid and advise the President, who shall in the exercise of his functions act in accordance with such advice. Proviso. Provided that the President may require the Council of Ministers reconsider such advice, and either generally or otherwise, and the President shall act in accordance with the advice tendered after this reconsideration. Therefore, the President has that discretion. So in a case where the President's doubt is triggered, the President will act. Therefore, there is an inbuilt guarantee that any departure by the Cabinet or the Council of Ministers will certainly be addressed by the President. If you want to doubt the President, of course, that's a different question. Therefore, there is an inbuilt guarantee available there.
I would also on that one address within my this question I'll address.
Yeah. Yes, but please.
Well, just straight trying to answer this question that is the being convention. Interestingly, in case of a CAG appointment, which went initially to Delhi High Court, and this came to this honorable court later, and my lords agreed with the Delhi High Court. This was the question which was there, that what do you do? What kind of a convention it is there? And I just want to point out that because that should throw some light that what is the nature of convention which is carried out in these kind of cases. This is Gopalaswamy and others. This is 2014. I'll show later this because some debate on the manner. Let's can kindly come to page 26, para 41. Yeah, page 26, para 41.
So page ratio.
Yeah, please. Yeah. Please. The other decision referred to by the learned counsel for the petitioner being Royapa's case and the decision in Manaklal and Ranjit Thakur Supra are unexceptionable. In Royapa's case, the Supreme Court observed that the equality is a dynamic concept with many aspects and dimension, and it cannot be cribbed, cabined, or confined with the tradition and doctrinal limits. It was observed from the positivistic point of view, equality is antithetic to arbitrariness. It was further observed that in fact, equality and arbitrariness are sworn enemies. One belongs to the rule of law in a republic, while other to the whim and caprice of the absolute monarch. Where an act is arbitrary, it is implicit in it, it is unequal both according to the political logic and the constitutional law, and is therefore violative of Article 14. There is no denying that there should be no arbitrariness in any state action, including the appointment of the CAG. The quarrel is not with this principle. The question is whether in the facts of the present case, there has been any arbitrariness in the appointment of the respondent as the CAG. In our view, there has not. The respondent number 2 was appointed following a time-tested convention. As in the appointment of all previous CAGs in the past, so too in the present case, the CAG has been selected from amongst the civil servants who have rich and varied experience in the public administration. The procedure that has been established has worked itself into the convention over the last several decades is that the Cabinet Secretariat, which is headed by the Cabinet Secretary, who is the senior most civil servant, having knowledge about the competence and integrity of the civil servants of the government, sends the list of the shortlisted names approved by the Finance Minister. to the Prime Minister for his consideration. The Prime Minister thereafter considers the said shortlisted name and recommends one out of the list to the President of India for his approval. After the name is approved by the President, the CAG is appointed under the warrant and seal of the President of India. This is the manner in which the appointment to the position of CAG has been made in the past, and this is the manner in which the respondent number 2 has appointed as the CAG. There has been no arbitrariness in this process. It is not as if the shortlisted, if the shortlist was not prepared by the Cabinet Secretary, it is not as if the Finance Minister did not approve the same. It is not as if the Finance Minister has not recommended the name to the respondent number 2 to the President. And it is not as the President has not approved the name of the respondent number 2. Therefore, the process of appointment which was followed as a convention has been followed, and there is no deviation from the same. Therefore, it cannot be said there was arbitrariness involved in the appointment of the respondent number 2 and so on. But if we look at this method, which is a called convention, which is there, and what is the in any public administration system to say that because Prime Minister is sitting with the President in terms of the conduct of business rules, and virtually somebody is be picked up without analyzing that what is the background of the person, how much experience he has got, how much period he has worked, which areas he's worked. There is certainly some kind of an application of mind. In absence of any evidence which can come in a judicial review before this court, to presume that there is nothing which works except that the cherry picking which goes on. In my respectful submission, these are conventions which has worked for a very, very long time. Today, the assumption to be raised at a point saying that I will not believe you that the process is independent because you are unable to show me each file how it is being done. For the parties, this can be done. If somebody is aggrieved, one can come forward and disclose all that policy. But when we are testing an application of an article of the Constitution, and unlike a statutory provision which is to be looked into, whether that kind of incisive examination required to arrive at a finding that we think that something more is required and to be laid down. But the one specific, very interesting aspect on the independence of judiciary angle came in, on the tenure based. But in 2017, the Finance Act 2017 came and multiple tribunals were merged. One very important departure was that unlike in the respective acts, the tribunals were provided, the date of retirement was 62 years in some case, 60 in some cases. In 2017, the Finance Act said that 5 years is there and there is a provision for reappointment. The first act was not there, it was amended 2017 came. One of the argument was raised in Madras Bar to say because the tenure is 4 or 5 years and you have a power to reappointment, you can keep control over him. And therefore, independence of judiciary is affected, relying on all those case laws. Court examined this position, looked into this aspect and said that instead of 4, 5 years, 5 years is the relevant period. The 5 year has been subsequently been a new act. We made 4 years. That's also under test today, which is coming up before the court. But so far as to look at a very important factor of a tenure and very important factor of a reappointment, which is to be made by that, is it to be pitched to a level to say it is going to affect the independence of the judiciary and consequent functioning, these quasi-judicial or judicial tribunals which are going to function, is to be raised at level? The court said nothing that can't be done. And one very more interesting aspect was also noted by Justice Nageshwar Rao in that is, can anticipation or a threat in future can be basis to declare any law unconstitutional? That was, and these were the words used in that, because I can read those paras, I pointed that out specifically in Madras Bar, which has been there. The court said that this is not the examination. You need to show in a certain instance that as a matter of fact, there is arbitrariness which has, as a matter of fact, has taken place. Those are the instances where we need to look into this aspect, and then only we can act. We can't declare a law unconstitutional based on that there is a threat, there is an apprehension, there is a likelihood which is likely to happen. All these instances which are there, this is may I request if my lords can call for 2026 SCC 1 minutes.
2026
SCC page 1 minutes.
Page 1.
Page 1. My lords can come to page 147 in this list.
Which para you said?
Para 144. My lords were examining the Finance Act of 2017. Para 144, 145. This is on page 137. May I please? I'm sorry.
Yeah.
Hello, this is Togi got page 137. Please understand. On examining the constitutional scheme, the statute which had created tribunals in the precedence of this court, laying down attributes of independence of tribunal in different facets. We do not think that the power to prescribe qualification, selection procedure, and service condition of members or the other office holder of the tribunal is intended to vest solely with the legislature for all times and purposes. Policy and guidelines exist. Subject to aforesaid, the submission of the Learned Attorney General that section 184 was inserted to bring uniformity and a view to harmonize the diverse and wide-ranging qualification method of appointment across different tribunals carries weight, and in our view, needs to be accepted. 145. Cautioning against the potential misuse of section 184 of by the executive, it was vehemently argued by the Learned Counsel for the petitioner that any discretion by the executives of such power threatens and poses a risk to the independence of the tribunal. A mere possibility or eventuality of abuse of delegated power in the absence of any evidence supporting such claim cannot be a ground for striking down the provision of the Finance Act 2017. It is always open to the Constitutional Court on challenge made to the delegated legislation framed by the executives to examine whether it conforms to the parent legislation and other laws, and apply the policy and guideline test, and found conflict can be struck down. As I understand, this is a delegated legislation. So, but the question again is that can a potential threat can be a ground to say that some action is required? And second, the rules of the procedure, which whether it's a selection appointment, can only by virtue of a statute which should be provided. And these high functionaries which are operating in the functioning of the electoral democracy in the country, which is functioning fine, where the institutional setup prevents or provide a check that this should not be abused. In that case, should it be treated as there is a vacuum or a gap where the court required to step in? Well, that's in my respectful submission, the question which requires consideration by the law.
Since you activized us on this judgment,
yes,
we'd like to make use of the opportunity to just ask you to read para 200. 201 and 218. Attorney General and Solicitor General are also here.
Yes.
It's an opportunity for us to just ask you this.
So let's
page 200.
Para
200, page 165.
165. Yes.
Presently, there are 24 statutes, and it comes to 24 such statutes. And then paragraph 201, you may read.
Please, I will start with 201. Such statutory appeals that take away the inherent ability of the Supreme Court, as envisaged in the Constitution, to regulate cases before it by confining its consideration to cases involving most egregious of wrongs and or having the greatest impact on public interest.
And now you read para 218. 218. 172.
Yes. It is apparent, that's all it's apparent that the legislature has not been provided with the desired assistance so that it may rectify the anomalies which arise from the provisions of a direct appeal to Supreme Court. Considering that such direct appeals have become serious impediments to the discharge of constitutional function by this court and also affects access to the justice for citizens, it is high time that the Union of India, in consultation with either the Law Commission or any expert body, revisit such provisions under various enactments provided for direct appeals to the Supreme Court against the orders of the tribunal, and instead provide appeals to the division bench of the High Court, if at all necessary. Doing so may merit benefit in addition to the increasing and affordability of justice and more effective constitutional adjudication by this court. It would also provide an avenue for the High Court judges to keep pace with the contemporaneous evaluation in law and hence enrich them with the adequate experience before they come to this court. we direct that the union undertake such an exercise expeditiously and preferably within a period of 6 months at the maximum and fine and place the finding before the parliament for the appropriate action may be inflicted.
Has anything been done? The November 19, 2019, judgment date.
Yes.
Something is going on, my lord. It's my vague recollection. But the problem, my lord, this is again from my recollection, I'm saying. The problem is the statute provides that the tribunal, some of the tribunals would be presided over by
Supreme Court judge.
by a former judge of this honorable court.
That is the.
And thereafter appeal going to the High Court, my lord, doesn't appear to be. But you know, that logic may perhaps not be a correct logic for the simple reason that a former honorable judge of this honorable court, if delivers an award in a say 10,000 crore arbitration,
Go to the district court.
to the district court also.
Exactly. So that you know, we don't know why.
I'm sorry.
On a daily basis, we encounter this. That's why we ask you.
It's a very.
My understanding, there is no
parallel
problem.
to- I'm sorry.
Whether the award is by the Chief Justice of India or somebody else.
No.
It has to go to a forum and not prescribed.
Competent. That's what I was.
It's not prescribed. Merely because it goes to a district judge doesn't mean that the Chief Justice of India award is being overruled. No.
No, it's the
It's a mechanism.
award, my lord, which is.
It's a mechanism. It's authored by Chief Justice of India or judge. This court.
That's exactly what we think. Therefore, the order of the tribunal can also be appealed.
Yes,
That's exactly what.
Whatever man by it, he might be this court.
This
Yeah.
court should be now.
I-
This court is dealing with this case. These are the cases, kind of cases
Right.
we should be
Your
giving.
lordship should be hearing. Yes.
Right.
But this has to be a constitutional court in
Absolutely.
real sense of the term.
Absolutely.
And my lord, there can
And
be.
that's why it's rightly said. Before
Right.
coming to this court, you are never occasion to deal with.
Right.
And for the first time through these appellate tribunals, which in expertise, people are there. Now coming traveled straight over to this court.
You don't know what your action.
I only want, my only add on, I just want to stop the flow.
Mr.
The anxiety,
There's 2 minutes he wants to say. Yeah.
the anxieties which are again shown in para 2 and 3 is that the nature of the jurisdiction of the court and its position as a constitutional, deliberator. If that is going to be anyway diluted, it's going to be affected, then why flood the Supreme Court with kind of appeals without
Not
internal
contemplated,
assistance?
not contemplated by the founding fathers.
Without internal assistance, not only here, even in US. There are several instances where statutory appeals go directly to the US Supreme Court. I can give those instances. I'm not giving a comparison. But then the point of concern is without anomalies which arise from the provision of direct appeals. Therefore, the direct appeals, if they are mechanically worded, one statute replicated like that, then there are some anomalies even in the consideration by the court as an appellate court, a second appeal, section 100, all that. Notwithstanding all that, could be anomalies. That is where the anxiety of the court is supposed.
That's right. We are just pointing this out. When Balbir Singh
That's right.
pointing
For
it out.
for example, my lord, in the CAT, your lordships are aware,
Correct.
that it goes directly to the division bench of the High Court.
That's why because judgment of this court.
As I said, the nature of it is there is a matter which requires your attention. There is a trigger point, there is something which is happening. That's where 218 comes in. So we are all coming back on the same wavelength.
We'll raise, we'll
Mr.
come back.
Balbir, only one question to you.
Please.
You have cited the judgment of the Delhi High Court,
Yes.
the CAG,
Yes.
and you have asked us to go through this paragraph 14,
Yes.
41, which you quoted last.
40.
But if you go to this very page, paragraph,
Yes.
there is a mechanism in place, which was placed before the court, and court has noticed it. If you come to which page you are referring to,
Well, this was on page
Human 5, the other decision.
The decision. Yes.
If you read it downwards, there was a mechanism in place.
No, this is a convention. That's what we call convention.
That's why we are requesting you.
Yes.
What is the mechanism in place in your case? You see, if you go downwards, last paragraph, in our view, there has not, respondent number 2 is appointed following, you got it?
Please.
Following a
Yes.
time-tested convention, and the test is there.
Yes.
We want to know from you, what is the test in place in your case, as here in the CAG?
Well, my understanding is that this is what we call convention, but
God knows, we
post
check
lunch
it.
will answer this question. Post lunch I'll answer.
I'll take some time after. Mr. Balbir.
Lordship is hearing this matter continue.
We continue.
Great, good one. reservation matter. So when they calculate, it's a very, very comprehensive data which is being maintained. Right today, if it is to be identified in railway particular department, particular section, who has been appointed, his origin date of appointment, under which category, through the interview rules, through the promotion rules, which postings he have been. So all those details are being maintained. Once that list is prepared, based on that, the panel of name is given by Ministry of Law. And like any ministry, they have their own ways to look at it, which is being carried out. And based on that, the list goes to the Prime Minister with the note of recommendation.
Has there been any occasion when you have overlooked the senior most election commissioner in the matter of appointment of the chief election commissioner?
Because I can check that, but I mean, right now may not be positioned, but I can take this question and can.
We just wanted to know.
Yes, Manoj.
If you are given the right to supersede,
Yes.
then you will have yes men. You'll be queuing up and they'll do whatever you wanted them to do, so that they will get to the post and satisfy them. Completely erodes seniority. I mean, independence.
Well, that can be one way to certainly that there is a
You
possibility.
don't know how you do it.
Yes, Manoj. But this
Big system.
well, then I think is going to be most important question would be, I mean, I'll certainly answer this one. I'm duty bound to answer this. But in each these cases, that to what length this inquiry is to be made. We were on a convention that there's some convention which is being followed. There is some method which is there. And that method has got some basis to go because the DOPT being the highest authority which is maintaining the employment record of Government of India in different ministries. And that carries out and the panel goes to the respective ministry, which is Ministry of Law. There is some exercise carried out, the final panel name is given. So far as this is the process which is being carried out.
Yes.
I wanted to show that it appears that what is the current setup of the election commission in the country. Because one aspect was raised that they need a separate secretariat. There is the independent secretariat, but currently this is available on their website also. So it's not I'm taking something from outside. That what is the current structure of the election commission?
May I just take a moment? Because the estimate on both sides is that it will continue to May 501.
May not. We have said maybe at least by half an hour we'd like to devote to.
All right, very well. Then
we want to begin.
No, very well. No,
By 3:30.
no problem.
So, to your lordships would like to continue tomorrow morning?
Of course we will continue.
Tomorrow there will be some.
We'll be continuing. We will not be breaking up the constitution bit. After this is over, we'll stay.
Lordship.
The Jallikattu.
Your lordship.
We will just continue. The bench. No.
Grateful.
Tomorrow, there is another constitution bench, but there's no problem.
True. But then we will not break up this bench. That's all we are saying. Who wants to address this in Jallikattu?
But in any case, we have to address, Lord.
Lord, in this matter, we would like to respond after Mr. Sharma and Mr.
That's right. We are going. Let's see how we will be. Yes.
Grateful.
Well, let's kindly see the setup which has been explained.
Yes. But we just keep a time on this.
Well, I'll wrap up in 10 to 15 minutes.
Yes.
The commission has a separate secretariat at New Delhi consisting of about 300 officials in a hierarchical setup. 2 or 3 deputy election commissioner and the director general, who are the senior most officer in the secretariat, assist the commission. They are generally appointed from the National Civil Service of the country, are selected and appointed by the commission with tenure. Directors, principal secretaries, secretaries, under secretaries, and deputy secretaries support the deputy election commissioner and director general in turn. There is a functional and territorial distribution of work for the commission. The work is organized in division, branches, and sections. Each of the last mentioned unit is in charge of section officer. The main functional divisions are planning, judicial, administration, systematic voters, education, and electoral participation.
Treat it as red, David.
Yes, so one can take it as
We are just noting it setup.
yes. So there is a setup. Now this setup linked with, if my lords can take the People Representation Act of 1950, 1950 People Representation Act.
1950 Act.
50 Act. The endeavor is to show how the statutory breakup of the administration of the entire exercise, going up to the last mile of declaration of result, and what is the involvement of the commission or the commissioner for that matter.
Just give us the sections.
Yes, I'll just give us.
So that you know.
I'll just give those
You can
sections.
give a brief note if you don't know.
I'll certainly give that.
That will do. So we'll just notice as how the RP Act minimizes the importance of this is what you're trying to say.
Yes, Honorable. The entire process is very, very independent. Different functionaries are allocated different jobs.
That's right.
Even this goes to the extent section 60 say, how do you declare result? No need of interference unless and until the election commissioner says that in absence of any direction.
So just give us those sections.
Well, I can
separate note. We'll make it give a note by Balbir Singh.
I'll give the note on this what is the scheme under the People Representation Act so far as the independent functioning is concerned. Yes, yes. But the one judgment which my lords have seen numerous times, the MS give. Just one para of that I want to read.
Okay, paragraph.
Well, the last paragraph that is at. Well, my lords can take the compilation for a minute.
It just gives the drift of it. What is it? What is it?
Well, basically, there the request was made to the court that please make some guidelines so far as to build in the audio altum partum rule, where there is a dispute in the candidature of someone, you frame those guidelines. How the court reacted to it, let's may kindly see that. Yeah, this is page 1384 of this.
1 minute.
I'm sorry.
Paragraph you have not given.
Well, I'll just give that. Page 1445, para 130, 130.
Begin.
Yes, please. Being not altogether certain of all the facts and circumstances that may be made available in the appropriate forum, it may be a premature exercise by this court even to lay down guidelines when there is no hidebound formula of rules of natural justice to operate in all cases and at all times when a decision has to be made. Justice and fair play have often to be harmonized with the exigencies of situation in the light of accumulated totality of circumstances in a given case, having regard to the question of prejudice, not to the mere competent in an electoral contest, but to the real and larger issue of completion of free and fair election with the rigorous promptitude. Not being adequately informed of all facts and circumstances, this court will not make the task of election commissioner difficult and embarrassing by suggesting guidelines in a rather a twilight zone. Well, that's what I'm saying, that the court was very, very guarded in this, in spite of, and interestingly, in this particular dispute, court said they should be heard. So even that was
in which year? 1978.
Yes, this the
44 years ago.
December 2, 1977. Yes,
Yes, then.
Well, the one more, just one para in that, the 1986 4 SCC, page 78, para 15. There, the prayer was made that the appointment method of election commission be equated with the judges. Court said refused. That's the, I think, Malajat. That was refused in that case.
86 or 96?
Well, this says 1986, 4 SCC, page 78, and para 15. Yeah. Well, if I summarize what I wanted to point out was, but the first is my humble submission looking at the scheme which has been there right from 324, 324.5, respective law being made, people representation being there. This is a scheme in itself, even if looking at the Constitutional Assembly debate in terms of reading the mind of the constitution makers. There is no vacuum which today.
No vacuum.
Yes, that's the first submission I have. Second submission is that why subject to law has been put in 324(2), noting the background debate on that aspect, is that the freedom has been given to the parliament with the test of time. What is the time and what is the stage and what is the event should be the time when this should be exercised. Before that, the process which has been provided, if that process has got any error in terms of functionality of the commission, then this court is there to look into it and has been corrected on a numerous occasions. Therefore, this not is going to mandate to say that, well, if this argument would have come in 1960, assuming for a minute, and this would have been looked at from the point of view, say, no, you please frame a law in 1960, a law should have been framed. That could have been there, and today the situation. And with walk of life, well, I don't think the society is going to improve. The distrust and mistrust is going to increase by virtue of integration it has emerged in the society. So there can be a different features today we may not be even contemplate. And like in that privacy judgment, Justice Nariman said that so far as at the constitution making stage, the privacy would have been a very different meaning. Today, with the technological developments, it has completely gone into a different realm. Even terms of a location, geographical jurisdiction, nature, simple comment. So contemplating that these are the changing dimensions which can come. And underlying fact is that today there is no pointed fact which requires that some correction is there. No trigger point. That's the third thing which I want to point out. Fourth is that the test of Vineet Narayan or test of Vishaka which has been sent, two fundamental factors which are extremely important. One is there was a trigger. Second, there was a consensus where the union also was wanting that since there is a vacuum of any statute existing and not going to the umbrage of constitution to say that there is some method has been given. In that, even both the parties sat together. That may be IRC report, or that may be Vishaka Para 16, where it has been taken into note that we both agree that this is the area which is to be done. Third factor, which is important in this case, is those are the cases which are to be tested to the extent of violation of 21. So we are going to pitch, and those are the individual rights which are created. Today, also one argument can be that somebody who's going to go vote, he has got a right to vote, and therefore there can be a breach if independence is not there. But when we look at those judgments, I think the fundamental point was that if there is a impact on an individual, life and liberty aspect comes into it, or there is some grave failure, like CBI couldn't file in a charge sheet in time. Tenuous. Yes, that is the third thing which I want to point out.
Tenuous.
Yes. The fourth is the efficiency and independence is not in dispute today. And desirability can't be a test to step in.
That's we have seen.
Last, the reports have been a troubling point for my lords because my reports been saying there is a contradictory in the same pages what we have read. The simple example I'm giving, they're saying the independent secretariat there, but the charge can be through vote. There's no need of a charge on a consolidated fund. It's fine. So those kind of are there. And most important answer, these kind of reports have been considered. One I pointed out in case of a judge's case. And second is these reports are a constant endeavor to upgrade the administrative functioning of that. Correct. So whether those are to be treated as sacrosanct at every stage and necessarily to be formulated in law, in my respectful submission, may not be the right way to look at this. And the last being, whom we are today doubting in absence of any action, are people with the administrative experience of 30 years. There is some check with the government which is maintaining, and we have not come across somebody who's been a fundamental charges have been leveled against any particular commissioner, in spite of that Ganguly and Tendulkar battle going on between them, which has come to a number of times. No, at no point seriously this has been pointed out saying that a man of zero integrity has been taken up, and these are the charges against him, and therefore that's not a test even.
Is there any prohibition being there getting an assignment after they vacate the office of election commission or a chief election commissioner?
Well, there is no bar in that. There is
No
no
cooling period.
There is also no cooling period also. There is no prohibition in that and there is no cooling period.
No, and
Yes.
historically, have they been given subsequent assignments?
But I understand in one particular. No?
There's no assignment. After you, there's no assignment.
All right, that's so the more credible.
But if I'm not wrong, in civil services, there is a cooling period, those who retire. And there is a cooling period of 1 year or 2 years. I think 1 year is their cooling period is there.
Yes.
Under that. So this was not considered that. So this election, appointment as election commissioner is not nothing to do with the cooling period there.
Nothing.
So the day you retire, you can become an election commissioner. So where the cooling period comes in?
Pradeep, that's what I was trying to find out.
No, the cooling period is there.
Yes.
Now where it will apply, we don't know.
The interesting part would be
In civil service, cooling period is there.
civil
But every
service.
2 years, reduced to 1 year.
So would it be equated the constitutional to this? These are not that some advertisement is being given and right application. This is based on a judgment, which is based, whatever factors are taken into it. So equating the constitutional appointments and equating the civil appointments was maybe a little different, where the rules and regulations are far more stringent to make the administration function and control knowledge. So broadly, in light of these submissions, my respectful submission is that there is the existing machinery which has worked well.
Thank you.
This may not be the stage, Malathi. I'm so grateful.
I think the fundamental
What do you
point
want
that
to
you
say?
have,
What do you want to add? Virtually everything has been said.
I'm sorry.
fundamental point that you are trying to raise is, brother, just one,
Sorry, go ahead.
is that these very machinery which is in place, the officers who have been selected, they have regularly conducted election all these years
Please.
without any, and the voting has also been to the extent that is expected.
Yes,
So therefore, there is no trigger point, that's the word.
that's right.
And the headaches that you have used the expression
Please.
are obviously something which can be taken care of on a case-to-case basis if there is a breach of fundamental.
I'm grateful. That's what I want. I'm grateful.
Yes, Mr. Mehta. You can say.
Well, I will not repeat anything, but not,
You're also appearing for Union of India only.
yes, yes, for Union of India. But I am coming last, more logistically, not that,
Union of India, yes.
yes, please. To answer the first question, last question first. Whenever the Constitution has envisaged that a person who holds a particular office will not get any other assignment, as my lord rightly put, the Constitution has provided.
There is a bar.
And that is under Article 148 of the Constitution, Comptroller and Auditor General.
No such bar.
There is no such bar. Lord, what essentially, my lord, we are debating on petitioner side, respondent sides, and troubling your lordship, what the constitutional provision should have been for an ideal appointment or an ideal process of selection of election commissioners, my lord, which, in my respectful submission, may not be a subject matter of proceedings either under 32 or otherwise. If there are any lacunas, if at all, and I will point out there are none, it is for the legislature to fill in, not by an act of parliament, but by a constitutional amendment.
Here, Mr. Solicitor, the triggering thought for this is all these reports, law commission, etc., are somehow saying that it needs to be changed. So that is that,
Lord,
we call it a triggering thought.
correct, my lord. But the triggering thought, my lord, is always welcome. That necessarily, my
So
lord,
whether it's a constitutional thought or not,
the law or anything develops because of such triggering thoughts. But the question is, which forum will make that change? So that's essentially the argument we are making. Now kindly take the Constitution, my lord. For my satisfaction, I am not repeating, I am my lord, assisting your lordships in a different perspective. Kindly have, my lord, 324.
Please, got it in our mind, yes.
No, my lord, it's always, my lord, a little satisfactory for a lawyer when your lordships have the bare act in hand.
Yes.
Lord, your lordships may kindly come directly to 2. And the way, my lord, in which, my lord, the sub-article 2 is presented, I have a different perception to that. And your lordships may kindly consider that.
Yeah.
The election commission shall consist of the chief election commissioner and such number of other election commissioners, if any, as the president may from time to time fix, and the appointment of the chief election commissioner and other election commissioners shall. Now, Lord, mark this. Lord, this is the point which consumed your lordship's substantial time. Subject to the provisions of any law made in that behalf by Parliament, be made by the president. My lord, the initial impression, my lord, which one gets, and my lord, it has been given to your lordship, is that president will be the appointing authority. How the appointment is to be made will be made by way of a law as contemplated under sub-article 2. My lord, in my respectful submission, that is a wrong reading of sub-article. That's not the law which is contemplated, and I'll make that submission good. Subject, of course, to your lordship, meeting with your lordship's approval.
Yeah.
Kindly, my lord, takes Article 53, which is the law which is being contemplated. And then I'll again read sub-article 2. Kindly takes Article 53.
53.
The powers of the president. The law which, my lord, so far your lordships have been presented with, that there should be a law providing for a mechanism of his appointment. That's not the law which is contemplated. It's law under 53. My lord, please have a look at 53, Article 53. Lord, it is under the chapter executive, the president and vice president. I'll directly go to 53. The executive power of the union shall be vested in the president and shall be exercised by him either directly or through officers subordinate to him in accordance with the constitution. Leave it, we are not concerned, but not relevant. 2, we are not concerned, we are not relevant, I am skipping it. Please, my lord, now read, my lord, with me sub-article 3. Nothing in this article shall, that is the power of the president. A, your lordships may ignore, come to B. Prevent the parliament from conferring by law functions on authorities other than the president. Meaning thereby, in exercise of the powers under Article 53, sub-article 3B, Parliament can say that this particular power of the president would not be exercised by the president, but would be exercised by some other body. But I hope I am able to make myself clear. 53B is an enabling power conferred upon the legislature, namely the parliament, that it can, instead of president, invest the power upon someone else. Now, my lord, for my satisfaction, read 324B in this context.
1 minute. Is it this sub-article B, does it encompass all the defined powers of president?
Yes, all powers of president.
Assuming the situation, the president is the commander-in-chief of all the armed forces.
Yes, my lord.
Can parliament make a law today and say that no, not the president, but some other
He is
authority?
saying correct, your lordships are right, my lord.
I agree with the question.
Yes,
That is right.
but it's very rude to say yes, correct, to a judge.
No, sir,
Yes,
very rude to.
yes, my lord.
Can the commander-in-chief of the three forces?
I am reading, my lord, the way it is, my lord.
uh,
Nothing in this article, my lord, kindly see.
That's what,
It
so far
cannot.
as this litigation is concerned, that's possible.
No.
Academic, but this
The
is-
answer is no. The answer is in the article itself. Please read the article 1, sub-article 1. The executive power of the union shall vest in the president. So what can be delegated by way of a law is the executive power, not any other power. Executive power of the union shall be vested in the president and shall be exercised by him either directly or through officers subordinate to him in accordance with the constitution. Now that executive power,
that is the all-encompassing power.
not when he is the chief of the armed forces, he's not discharging
No, that's a
executive,
specific power,
the
yes.
specific power.
That's-
For example, power of granting pardon, etc. But here, my lord, all executive power, your lordship.
In Article 350.
Yes, my lord, all executive power is coterminous with the schedule. The schedule 1 in list 1 in the 7 schedule. Look, that is, my lord, now kindly read 324B2.
Solicitor General, see, 53(1) speaks about executive power.
Correct, my lord.
The executive power of the union government shall be vested with the president to be exercised by him. Now, sub-article 3, which you are referring to, it speaks about nothing in the article shall, which you wanted to read, prevent parliament from conferring by law functions. There's a distinction between powers and functions. The executive power of the union, in the case of, is the head of the, is a head. President is a ceremonial head, like the Queen or
Yes,
the King in England.
yes, my lord.
The executive power can be exercised only except in 2 or 3 established circumstances, only on the advice of the Council of Ministers. Now, how the Council of Ministers, who is to be consulted, it's laid down in under Article 77, read in the rules of business.
Correct, my lord.
Correct. So this may not have anything to do with it because we have no difficulty that the president's power has to be exercised.
I'm sorry.
Under 324B, on the basis of the Council of Ministers' advice.
So 324B neither uses the expression power nor function. It says the appointment shall be made by the president.
It's a power. It can only be a power.
That's how your lordships can read it, but it can be read even as a function of the president. And my lord, that may perhaps not make any logical difference so far as my lord 3B is concerned.
Yes.
It is that law which is contemplated that unless the power is conferred on someone else, the power will be exercised by the president. It's not, my lord, dependent upon a legislative power. And I tell you, lordships, the reason. What is the object? Look, there are certain functions.
While interpreting
Can I-
the provision, come out what you want to convey properly. Because we find it difficult. If you see 53 once again, and 1 and Article 3 subclause D again,
Yes, my lord.
I pointed out to you, something is missing in between. TC. 1 is exclusive power of the union vests with the president,
Correct, my lord.
or to whom he authorizes. Absolute, no discussion. If you come to 3, nothing is article shall be prevent parliament from conferring by law functions. As you've been told, executive power absolutely with the president. 3 only says functions or authorities other than the president. So if there is any other function which are delegated to authorities other than the president,
My lord,
this,
suppose,
by virtue of this clause, you can modulate and
take an example.
take away the power, the functions other than the president, vested with some other authorities.
Take an
But when the
example.
president is concerned, we don't think this B has any.
Look, take an example. Take an example, my lord. Parliament, in exercise of powers under Article 53(3)(b), makes a law that the power or function, whichever nomenclature we may give, under Article 324(2), shall be exercised by a body consisting of A, B, and C. That is permissible. But if that is not there, then the president will have the power to appoint.
That is what is specifically provided in 324B itself. The making of a law by parliament is contemplated in 324B itself. You don't have to go to the 53B for that. Because also you will see nothing in this article.
Yes, my lord.
53B speaks about nothing in this article.
Correct, my lord. That is one.
One.
Yes.
We are concerned with a separate chapter of the Constitution, which has a separate scheme. Even in the debates of the Constituent Assembly, initially the provisions relating to appointment of the Election Commission was contemplated as chapter to be included in the chapter on fundamental rights. They attached considerable importance to, so devoted a separate chapter to the Election Commission, dealt with in a standalone provision, then followed by 3-4 provisions which make up the whole chapter. The making of the law by parliament, if you see the entire discussion, they had a lot of debate of what is going to happen if the president is going to be given the power. So they said somewhere down the line, they expected that, okay, if a situation arises, parliament may step in. You can argue that, that period has not stepped in because you have got a very efficient setup. People are being appointed. Down the line, there are all very good people. So there is no trigger point. Parliament, it's a matter of wisdom. It's not a matter of legality.
I'm obliged, Lord. I could not bring
And
my
I can
own
understand
book,
that there is a difference between power and function.
Yes, Lord.
See, with respect to appointment, see, for example, the judges, the power is exercised for appointment.
Was,
then-
used to be. my lord.
See, administering ought to the chief justice.
But used
It's
to
a
be.
function,
But
it's
used
not
to
the
be,
power.
used
So
to be
there is
exercised.
difference.
My lord, used to be exercised. I don't want to go into that, my lord, controversy, but
So there.
our used to be
Very
exercised.
carefully these words are used.
And my lord, it is during that exercise of power that we could, that system gave Justice Krishna Iyer and Justice H.R. Khanna. Thereafter, we made a better system. Recently, there was an article, my lord, yesterday or day before yesterday, where, my lord, some expression was used. I may not agree with Mr. Dushyant Dave in everything, but I agreed with that, my lord. But now, without using the expression which he has used, my lord, that this honorable court has usurped the power of the president. I don't use, my lord, I don't agree with that. Be that as it may, my lord, that's not the question, my lord, right now, for your lordship's consideration. So your lordships are right, my lord. But, my lord, my respectful submission is, and I leave it at that, because that's not a submission, my lord, in vain, submission in air. Your lordship's reading of Article 324B2, that in absence of any power, how do you exercise the power? My respectful submission.
There is no difference.
I'm not, there is, nobody says, my lord, there is no power.
Nobody has a case that there is no power. Point is whether
Correct,
it's come to a stage where.
But, my lord, if there is no methodology of exercise of power prescribed as suggested by them, then, my lord, my respectful submission is that constitutional silence, as, my lord, a good word, my lord, fell from your lordships, cannot be filled in by way of a judicial interpretation. It can be done only and only by the parliament. That's, my lord, the position. Lord, now, yesterday, my lord, during the discussion, my lord, there was some debate as to whether presence of someone who is, my lord, I would say, non-executive person. Lord, your lordships are aware, my lord, the separation is very clear. Judiciary, executive, and legislature. There is a theory of doctrine of the doctrine of separation of powers. Lord, your lordships were pleased, my lord, just mull over it, my lord, as a, my lord, loud thinking that maybe the presence of someone else might ensure, as, my lord, going by the reports, that things are not messed up. Lord, there I have a serious problem, my lord, as an officer of the court, and please don't take this otherwise. This is my submission as a constitutional proposition, not individuals or institutions, as a constitutional proposition. Lord, constitution makers were very, very clear that some of the powers are vested upon executive and legislature, and some of the powers are vested only on the judiciary. The distinction was some of the powers the constitutional framers thought should be entrusted to the people's representatives chosen by the people, who are answerable and accountable to the people every 5 years. That's why, my lord, this separation of powers. One organ will not entrench upon another organ. Second organ will not entrench upon the third organ. That's how, my lord, the balancing system in the constitution functions. Now, my lords, if your lordships were to consider that someone else, the presence of someone else might help the situation, my lord, what are the problems? Constitutional problems. I'm not on individuals or institutions for that matter.
Why you're asking someone else? We never proposed someone else.
No, there was a, my lord, that for example, my lord, presence of the Chief Justice of India or some judge of the court, that fell for, as a
There's really a kind of a deliberations going on.
no, my lord.
Someone else.
Therefore, my lord,
We never said someone else.
if that was deliberation only and not going to materialize,
There's only a deliberation going on.
Yeah.
Nothing. Someone else you have come.
then I have nothing more to add.
Someone else.
I have, then, my lord, I have nothing more to add.
According to someone else means whom?
My lord, I didn't want to name, but my lord, as suggested, that for example,
It's my submission, it's my submission which I've made.
That's correct.
I'm making clear.
You're making a submission.
then, my lord, let me deal with. Let me deal with. His
That is for our
submission.
consumption.
No, absolutely. So I don't want Mr. Mehta to have the impression that we haven't made that. We have made that. I've made that submission.
I'm grateful to my learned friend. Lord, his submission is, let me put it this way, that there should be a presence of someone who is not a part of the executive. That's the submission, and I'm meeting with that submission. Did not fall from
That
it.
also sufficient.
Yeah.
That's correct.
But now, the problem is this. That would necessarily involve a process of rewriting the constitution. That's the first problem.
Correct.
Second, the moment this honorable court says that but for the presence of a non-executive, maybe not from the judiciary, but not a part of the executive, the selection would not be proper, would depend upon true presuppositions, my lord, which your lordships will presume. A, it is not possible that the executive alone can discharge the functions constitutionally conferred upon it in absence of some outside presence, which negates the very concept of democracy, and democracy is in the preamble. It's a basic structure of the constitution. Executive consists of the people's chosen representatives. If one finds that one representative is wrongly chosen, that's his problem. Democracy works like that. Democracy works, my lord. He has selected one person to take all executive decisions, and your lordship's decision would not, in my respectful submission, be based upon a presumption that but for an outside presence, the executive will not be able to discharge its functions honestly or with transparency.
When you say that, historically, look at what happened in the CBI director's case.
I'll come to that.
Is not the CJI participating easy?
I'll come to that. I'll come to that, my lord.
So the democracy, when you talk about democracy, we don't want to say many things, but we just want to say that our court's history, our judgments, how our courts are approached, how the executive has accepted it also. There's no difficulty about it. CJIs do participate.
I'm not on individuals or institutions.
We are talking about.
I'm on constitutional proposition.
There we are talking about. This is also part of democracy. The CBI director, vigilance commission, I think CVC.
Let me answer that.
So they're also.
Lord, they're the basic. Anything I can. But appears to be something very interesting, though appears to be privileged communication, my lord.
No, it's just that.
Sometimes lighter moments are always.
Lighter moments we are discussing. I've got a very lengthy miscellaneous my list on Friday.
So that's my lord. What the theory we used to, my lord, learn in first year of law, voluntary non-fit injury. Your lordships have taken that injury voluntarily, but it can't be helpful.
So you were saying about the
Yes,
CBI
please. Lord, CBI director before Vinit Narayan judgment, Lord, was merely an officer of the government, not even a statutory functionary. Please, Lord, bear this distinction in mind. A mere officer, a statutory functionary, and a constitutional functionary.
Correct.
CBI director was a mere officer, was not even a statutory functionary, even till the law was subsequently amended. There was a vacuum as to how the person is to be selected. And the selection process by way of a constitutional mandate was not conferred upon the highest constitutional executive functionaries. Therefore, in absence of any, my lord, provision, your lordships, my lord, as a mere stopgap till the legislature steps in, because it was an unoccupied field, your lordships, my lord, said that. Lord, I would very earnestly urge, as a constitutional proposition, not to compare director CBI with a constitutional functionary, because, and my lord, I'm a word of caution, my lord, as an officer of the court. Similar provisions are made. Comptroller and Auditor General of India is elected in this under the same is selected or appointed under the same procedure.
The same president.
Governor is also appointed under the same procedure. Now, if the argument is to be accepted, Lord, would all constitutional functionaries be appointed by the executive necessarily with the help of someone from the judiciary?
You understand? You understand?
Lord, my Lord, I very earnestly and with profound respect, my Lord, and as a constitutional proposition urge the theory of independence of judiciary and theory of independence of executive are equally sacrosanct under the constitution. That's the constitutional proposition. We cannot say that anything which interferes with the judicial organ of the state violates the independence of judiciary, but executive function can be interfered with, constitutionally speaking. It is equally sacrosanct.
Separation of powers.
Separation of powers, my Lord. And therefore, my Lord, I'll cite only few lines from some of the judgments, not the full judgments. It says the doctrine of separation of power stems from Article 14, equality. All three organs are equal in the eyes of the Constitution, and no one organ predominates the other.
It just straight away give those citations.
But my Lord, I have, my Lord, it is ready.
So you would like to.
My Lord, I can't run against the time, my Lord.
No,
But
we want, because, we have got a sort of time frame, and
I
your points you have really very, your characteristic way you have put across.
yes, I do.
Which cannot be missed by anyone.
No,
It is
I
not going to
I
go
wish,
over
my Lord,
and
yes.
they're going to think about it,
My
ponder
Lord,
about it.
and my Lord, no, my Lord, sometimes, my Lord, it may not, it's not a difficult,
We are not saying, yes.
it's a difficult responsibility.
Very serious issue. We have to.
Lord, it's a
restore
difficult
and-
responsibility, my
What will
Lord,
come of it is a different matter.
but my Lord,
We are only saying we have to give it a very serious thought what you are pointing out. A very serious consequences it has.
I can
That-
read the,
that is all that-
I'll not,
Yeah, we are saying
I
that.
can't
We are
do.
saying that we are raised a very serious. We are not.
so my Lord, the
We will-
first problem is that non-trusting the executive, that but for an outside interference, they would not be able to discharge the constitutional function is constitutionally impermissible. And second, again, my Lord, a very onerous responsibility to make this submission. But please take this as a constitutional proposition, not, my Lord, otherwise. To, my Lord, presuppose that it is only when there is a presence of one of the organs of the state, namely the judiciary, that transparency, accountability, and all other good things can be achieved, will also be constitutionally, my Lord, not a correct position. Lord, we have bureaucrats. Bureaucrats are doing amazing work. They are deciding policies of the nation. They are deciding what are the nation's national policies with other countries. Lord, there may be inefficient bureaucrats. There may be inefficient politicians. There may be corrupt bureaucrats. There may be corrupt politicians. But this is the position in every sphere of life. So mere presence of someone from one organ can only ensure transparency, maybe a fallacious fundamental foundation to make an argument on, which my learned friend has sought to make. That is my second submission. Therefore, the Lordships may kindly not travel through that path which disturbs the constitutional balance of separation of powers, because that might, we have to tread very, very carefully.
Absolutely.
And it might, why enter into an area which might have a
Very delicate. What you said
Well-
is right. It has to be done. Whatever has to be done, it has to be done with a lot of care.
yes. Because I at the cost of repetition say the independence of executive within the bounds of the constitution is equally sacrosanct.
That's in Article 50 also.
Yes.
The directive principle.
Yes.
There can't be two opinions about it.
Yes.
Absolutely.
Absolutely.
What we put to them also and what I put into you also, in 324(2), it says subject to the provisions of any law made in this behalf by the parliament be made by the president. Our question is, where is that law as on today in place which permits you to proceed and process the names for appointment? This
I bow down. I bow down. My lord, that presupposes my 53B argument is not accepted for the time being, my lord. I presumed it, and my lord, I go further. Because my first argument is that law is taking the conferring power on somebody else other than president. In absence of that law, the president will have the power. Look, suppose sub-article 2 is read as my lords have, my lord, kind enough to, my lord, say, and there is no law, then your lordships would make a suggestion to the parliament. Look, there can't be a mandamus to the parliament, nor there can be an attempt to create, to my lord, fill up that constitutional silence by way of judicial interpretation. Because we are dealing with Constitution of India, not a statute.
Would this solicitor then suggest that the court should not undertake the exercise of saying what should be the process, but can certainly nudge the executive to do something which is expected to be done under
Yes,
24?
yes, that certainly your lordships can do. But that in absence of the law, this will be the law. Till you make the legislative enactment will not be, my lord, constitutionally permissible.
All right. Okay.
Because we are dealing with a constitutional provision and not a statutory provision.
So we can now take from your statement that all appointments which are being made on the respective post of election commissioner or a chief election commissioner, they are randomly made on the basis of whatever the mechanism you consider to be appropriate.
No,
There is no law on the place.
Let me answer that, my lord. Let me answer.
So you
It's
said,
a loaded question.
you said that we have not come out with any law with the law.
Lord, my answer
Then
is
ask us.
Lord, it's an enabling provision, not a mandatory provision.
You could have said that, all right,
It's a
it is not
enabling.
mandatory, we have not followed it. Still, we have a mechanism in place,
Lord,
which is
kindly-
impartial and unbiased.
Kindly appreciate, my lord. It's an enabling provision. In absence of any law, it's not as if appointments cannot be made. No, my lord, this is something serious.
Yes.
Lord, the Constitution has conferred that power on the highest constitutional functionary, and he has his own way of appointing. My lord, I cannot, my lord, give an example. Otherwise, I would have given an example. My lord, all constitutional positions in all three organs of the state, including judiciary. There are no rules or there are no acts of appointment. Your lordships as a collegium do take into consideration intangible facts which are not written down somewhere, that this would be the seniority, this would be the marks for judgment writing, mark for personality, mark for court behavior, etc. These are the intangible things. It is left to the wisdom of the people who are again constitutional functionaries. Here, President of India is the highest constitutional functionary.
You are not aware of. The attorney has given us a statement today, a written statement. And para 6 was read over to us. You have a copy?
Yes, I have read it.
It's something different. What you say is different than what is para 6 is different. Please read it. For clarification for us. You have it, this attorney, please have it. Let us have this para 6. Say, attorney, this was a supplementary submission on behalf of the Union of India.
Yes, supplement, today's submission.
No, because today so many submissions were made. By convention. This is para 6, says by convention it has been established.
Yes, that's what I am
Have
saying.
you read it?
The Honorable President, I have read, my lord. The Honorable President has his own mechanism of selecting in absence of the law. But in absence of the law, which is not a mandate of the Constitution, neither the appointment would be illegal or can be termed as random, to say the least. These are all constitutional appointments made by the President of India, on whom power is vested by the Constitution.
You understood something. Nobody is suggesting that these appointments are illegal. And nobody has.
No, randomly made. Therefore, I must
What you're
answer.
saying is something different. What you're saying is, over a period of time from 1990 onwards, the government of India itself appointed committees, official reports, law commission reports, other committee reports.
Can be considered by the Parliament. Yes, sir.
So that's a question. That's the only question.
Certainly. Now, my lord, I come to, my lord, some of the judgments, and my lord, I conclude.
Yeah.
But one more, just.
Just give us, kindly give us those citations so that, and the paragraphs, which you.
No, I have quoted and highlighted. I'll read only highlighted part, not even quoted part.
Just, you don't have to read it. If you just give us a paragraph and we will.
No, let me, give me 5-10 minutes more.
We are telling you, we'll go through it. You don't, not as we will not go through it.
Lord, kindly, my lord, allow me for my satisfaction. Lord, kindly come to, first of all, page 16 of this. Lord, there is a new point.
Note, we'll see, we'll make a note of it, written submission from South Citizen. Go through each one of them.
No, I'm not, my lord, going
We are
to,
bound to it, do that.
Lord, page 16. My lord.
Yeah.
My lord, my point is,
Yeah.
the respectful submission is,
Judicial-
whenever,
You have raised judicial restraint, this.
no.
I mean, judicial.
Your lordship,
legislation, something which-
I'm sure your lordship's patience, my lord, I'm fully assured of.
Yeah.
Page 16, my lord.
Yeah.
Bottom. So the proposition is this. Whenever the constitution has envisaged consultation by the president in exercise of his function or power, it has specifically provided for.
That's a good answer. Yes. That was not argued by anyone.
No, not, Lord, I'm not repeating any of the
No,
submissions.
that's right.
Lord, please see 98.3, consultation with the head of respective legislative houses
It's,
while making rules of parliament. 124,
that's a new point. That's a new point.
consultation with the Chief Justice of India, or as it stood originally, etc., etc. Lord, I'm not reading all.
Replicated.
Therefore, my lord, if your lordship reads any other presence or consultation, would be necessarily, Lord, in my respectful submission, rewriting the constitution. Lord, now your lordship, my lord, kindly come to page 11 only, my lord. And I just, my lord, I'll not, my lord, I'll make your lordship's glance through it. That's all. I'll not read it. Only, my lord, allow me to read the highlighted part. Lord, page 2, Samsher Singh is the lead judgment on Article 53.
Yes, yes.
Kindly, my lord, come to page 4, para 31. Lord, your lordship's question, how the appointments are made, but as per rules of business. That's how, my lord, it is answered. The president acts as per rules of business. So, in absence of a law, my lord, which the petitioner contend to be the law under sub-article 2, rules of business govern the field. And, my lord, that's how, my lord, the constitution bench in Samsher Singh has held, my lord. Lord, I'm not reading it. I assume, my lord, your lordship would definitely, my lord, read it.
Each one of these.
Please read, my lord, Justice Krishna Iyer at page 6.
Yes.
Para 95, I'm not reading the entire thing.
Yes.
We are not unmindful of the agitational siege of parliamentary institutions and the anti-parliamentary build-up underway and the rashes of frustration showing up against the unsavory politics of power. But the limited task assigned to us is to interpret the constitution as it is, not to venture starry-eyed proposals for reform. Even so, sorry, madam, I'm reading. Even so, our activism in interpretation must not be bogged down by logomachy or blinkered by legalism, but be aglow with insightful observations of Chief Justice Marshall. Then, my lord, 138 at the foot. The president in India is not at all a glorified cipher. He represents the majesty of the state. He is at the apex, though only symbolically, and has the rapport with the people and parties being above politics. His vigilant presence makes for good governance, if only if he uses what Bejhot described as the right to be consulted, to warn and encourage. Indeed, Article 78, Lord, then, my lord, it is Lord, very widely, my lord, that I'm just not to compare a power of the President of India to appoint constitutional functionary with an officer like CBI director. That's not the purpose. Now, your lordships, my lord, I have cited TN session. Yes, my lord, your lordships may my lord, kindly go through.
We'll go.
Only two my lord, paragraphs I'm tempted to say. My lord, because of the prayers made, my lord.
Yeah.
One is, my lord, State of Gujarat versus R.A. Mehta. Lord,
Governor,
Lokayukt's appointment, my lord, where, my lord, very, my lord, succinctly, the Honorable Court has said, para 56.
56.
I give the citation, 2013, volume 3, SCC, page 1.
Is it part of this note?
No, it's not. Not therefore, my lord, I'll supply by tonight, by evening today.
Kindly
That's
repeat
all.
the citation once more.
I'll give that. My lord, 2013,
You're giving us a compilation.
volume 3, SCC, page 1.
Yeah.
And my lord, there are 5 judgments, all 5, my lord, I'll give. I rely upon, with para numbers I'll give. I'm not reading it, I'm reading only 2 paras. The principle of checks and balances is a well-established philosophy in the governance of our country under our constitution. If we were all to have our way, each person would be allowed to wage a war against every other person. This reminds us to abide by the constitutional law, followed by the statutory law. Otherwise, everybody would sit in appeal against the judgment of everybody. In view of the aforesaid discussion, the law as evolved and applicable herein can be summarized to the effect that the governor is bound to act on the aid and advice of the Council of Ministers unless he acts as a persona designata under a particular statute, so and so. Lord, similar are the Lord, propositions. And my last submission, Lord, what your lordships are called upon to decide or adjudicate or hold is a general sweeping law, that till the law comes into force, this will be the law, which in my respectful submission, not permissible. Any outside interference would violate the theory. Last, if any appointment is made, which is the appointment of an unqualified person or otherwise undesirable person, your lordship's power of judicial review remains.
See, there is nothing like unqualified person because you have not prescribed any qualifications.
Lord,
How do you say that
there was a case where
you understand what you're
I'm understanding.
Unfortunately, you have not put in place, like in Pakistan.
Wisely so.
Pakistan, they have put in place.
But we don't follow Pakistan mostly.
We are not.
And that's the wise thing we do. Well, look at the position they have reached, and look at the position we have reached.
What is the neighborhood? They have said, for example, how do you define a senior bureaucrat? Somebody who has 20 years. You are following that as a convention, fine. But when you say it is a codification, it has to be prescribed.
I'm not saying that. Lord, I think, my lord, an unwarranted expression, my lord, is taken up. Lord, any appointment, if can be wanted to be challenged, can be challenged before your lordships.
On what ground?
In what it was, Lord, there was
ground. On what
it was challenged. It can be, Lord, it was challenged, and your lordships were pleased to set aside the person appointed was having, excuse me, sir, was having charge sheets against him. There is a judgment of your lordships, my lord. I'll just, my lord, this is one of the judgments, my lord, in this, my lord. That was an appointment of CVC, I think. But the Center for PIL, my learned friend, my lord, has, and the name of the person was T.J. Thomas. No, not, yes. So, my lord, I'm not saying that your lordship's power is not available, but the power is not available at pre-appointment stage to decide the manner of appointment. The power is after the appointment is made, if there is some ground, but of course.
Thank you.
These are the sufficient.
Thank you. Yes. Yes. Bhushan.
Just 10 minutes. I will not repeat anything. Just on few things. That
you give a note, otherwise we'll not get anywhere. Please give me a note.
Give it to my document.
You can give me a note.
The whole thing is debated for the election commission.
Is election commission should be
You make it but strictly within 10 minutes.
Lord,
Just a moment. Let it just 10 minutes we want. Yes, go ahead.
Because at the foremost, I am not in the first matter. Election Commission of India is not a party, and rightly so, Milords. Because way appointment, Milords, we don't have a looker. So I am restricting it only to the second petition, which is Ashwini Kumar Upadhyay. In fact, my lords will see the prayers. It's a verbatim of all the reforms and proposals that we have sent to the Law Commission.
So you're supporting.
Replica of that, my lords.
You're
So
supporting.
what I'm trying to say is there's nothing new in that petition, my lords, from 1998 onwards till 2016, my lords. We had sent proposals after proposals, my lords, and it's my lord knows that the Law Commission has also proposed that we should have an independent secretariat, my lords. Also, my lords, insofar as the removability clause of the lords, insofar as election commissioners are concerned, my lords.
As they say, man proposes, God disposes.
So, my lords, my submission is, my lords, that should be looked seriously, my lords. But today's time, my lords, when we go through the parliamentary debates and all, my lords, those times have changed now. And as rightly put forth by my lords, that now there cannot be a single manned commission. It's not possible practically today, my lords. So in fact, even in the constitutional debates, my lord, it has been debated. There were objections even with regard to the removability clause, although it was not taken up, my lords. And Dr. Ambedkar probably said that, we are running short of time. So that is the reason why it was not debated in so much of detail. But, my lords, in today's time, when you say that you are co-equal, you exercise same powers, and if two of them, my lords, have taken a decision, they can take a decision, majority decision. Now, when you give so much of right, my lords, that you can actually decide an important issue on the basis of
What are you suggesting?
So what I'm suggesting, my lords, that the same, my lords,
Same.
because it has to be by way of a constitutional amendment, my lords. That's the point, my lords. We can't really go beyond that because the constitution very specifically says so, my lords. So I can't really go beyond that. But, my lord, it should be looked on because we have made those proposals.
They should make an amendment to the constitution so that the election commissioner should be put on par with it in regard to irremovability.
Absolutely.
Is what you want.
That is one point. Lords, as far as the, my lords,
And second, with respect to the commissioner, the secretary.
please, my lords. As far as the secretariat is concerned, my lords, now the commission works throughout the year, my lords.
So what is it that you want actually?
Because we want an independent secretariat.
Independent electorate.
What is the budgetary allocation?
And it should be charged, the budget should be, expenditure should be a charged expenditure.
Absolutely.
Like the salary of the judges of the High Court, Supreme Court. So it should be, so what will that not involve the court foraying into a matter of policy, finances,
But
telling the government to make it
my lords,
consolidated?
so far as these issues are
And if
concerned,
they make it consolidated, they put say 1 lakh rupees or 2 lakh rupees.
no, my lords,
This is
when
salary of
you
your-
have a removability clause, my lords,
How do you
which is
tell them
compared.
what amount should be put? How do we tell them what amount should be put when that should be charged? Otherwise, it's meaningless.
This can always come out from some kind of committee or consultation, my lords, which can look into it, my lords.
That's a,
That's a
that's a
point,
budget
because we can ask them to look into it very
So that,
seriously
because-
and come out with
Because
that.
obviously, my lords, all the finances and economical issues have to be dealt with.
that's a budget.
The Law Commission has proposed that. I can show that.
That's right. Let us see.
Because, and because there was one.
They all heard you, your submission. The complaint which you are making to us, they all have heard.
We have also put it
Attorney,
to them. We have
attorney
also-
and solicitor both have heard, but they're not.
So, it's on record, my lords.
And
It's
attorney then
properly-
will,
we have said so in so many words in our counter affidavit.
You're putting them to shame actually, that they're not able to.
There's nothing like that. Look, what
Better we have a
That's the beauty. That's the beauty of. That's the beauty.
because that in fact also shows that, my lord, I should not say that, my lord, but as an officer of the court, I can say that the projection is,
Why shouldn't you say what you wanted to say?
plus what I want, as an officer, I can say this, my lord, that the projection is that unless and until there is a mechanism, whoever is an incumbent is not doing his job.
Oh.
So, lords, we've been working, lords, I've been being a standing
Please repeat.
see our affidavit.
Please
So,
repeat your
as an
submission.
officer, I can say that.
Please repeat your.
What I say is, because as an officer, my lords, that the impression which has been given from the petitioner's side, that till the time there is a mechanism at place
For what? For appointment?
plus for appointment,
Ah.
the present election commission or in past, my lords, they have never worked.
Very good.
No, such a submission has not been made.
Because there was a,
In fact, no.
because
You see, that's pointed out also. Such a submission, don't take it to that level. In fact, what is being suggested, and Mr. Balbir Singh has rightly said that we have conducted elections on time. We have had good people, number of voters participating. So therefore, the system that is in place is, you can't say that there are aberrations there.
There were some suggestions.
No, sorry, there is no complaint.
Don't go
made.
by that.
That's-
You don't have to answer that.
Yes.
Came from my lords.
Oh,
that
sorry.
was a-
Nobody has said. Sorry, nobody has said.
Because the
They
second,
are completely silent on this issue. They never said that whatever the elections have been held in past so many terms, there is any kind of a aberration there. No, nobody has.
my lords,
Only with respect
No,
to
no,
the
not-
strengthening
let
of,
me put
strengthening
it-
of independence.
right, but the strength of
Strengthening of
council.
independence.
Because as
that
an
is
officer,
what
I
they
can
have.
say, my lords,
That is
it's
what-
strengthening, my lords.
Now what
No,
you
no.
said is not.
Let me put it this way,
Strengthening
just
of
because we are
independence is
uttering the name of Sheshan every now and then, it doesn't mean that all the others have been,
No.
brushed with a
No, in
black
fact,
brush.
in fact,
Black
because I
paint.
completely go down when it fell from my lords, that.
No,
was
don't
the
go by. Don't dwell on
Where
it.
it started.
Don't trouble yourself on that.
Because the second is, Milods, insofar as Milods, there was a question which fell from this court, Milods, about whether a right to vote is a constitutional right or a statutory right. Because I will just give the judgment, Milods, with paragraphs right, Kuldeep Nair,
What's your stance?
UCL.
What is your stand?
Milods, it is a statutory right, Milods.
Not a constitutional right. Not a constitutional right.
Only insofar as a voter right to know about credentials, etc.
What do you say about 326?
Because 326, Milods, it doesn't give a right to a voter. Right? Because 326, I will.
Kindly read 326.
Yes, Milord.
Entitled. What is entitled?
Please read 326. I mean, you are the election commission. You should be telling us that they are.
Only for qualification.
No. We just read it. Very important that you read it.
Please, Milord.
What does it say?
Milord, election to the House of People
Yeah.
and to the legislative assemblies of state be on the basis of adult suffrage.
Please read on.
The elections to the House of People and to the legislative assembly of every state shall be on the basis of adult suffrage. That is to say, every person who is a citizen of India and who's not less than of age on such date as may be fixed in that behalf by or under any law made by appropriate legislature and is not otherwise disqualified under this constitution or any law made by the appropriate legislature on the ground of non-residence, unsoundness of mind, crime or corrupt or illegal practice shall be entitled to be registered as a voter.
So these are words which are the lawyer knows. Shall be entitled, 18 years, not disqualified. Now, if you are going to say that the parliament's power, when it sits in its legislative power, is going to override the constitutional power, the constitution has contemplated giving the right. That is a fundamental thing. It was 21 years initially. This is lowered to 18 years.
That's right.
At the time of the constitution, that is what the debate is. That ancillary lawmaking by the legislature is contemplated for giving it actually teeth and flesh.
Yes.
Just because the disqualifications cannot be enlarged by the legislature. What are the disqualifications are mentioned in Article 326?
Please, Milord.
Can't be doing it. Now, if the legislature were to say, no, we will not do it, we will not make a law, certainly we would ban the person. We'll say that you are defeating the constitutional right. I mean, fortunately, we don't have that position. But therefore, it may not be correct to say that Justice Chalamishra was not right. When he said there is a constitutional right, we have to, of course, how we have to modulate it, how do you state the law is a different thing.
Because
It has its
My lord,
underpinnings
I
in the
bow down, my lord,
Constitution.
but it has to be looked into from in a particular set of.
That's right. 13 Tennessee page 1 proceeded to analyze four judgments. But the effect of 326, we'll have to see because this is a larger net. We'll have to pronounce on it. All right. Now let them.
If your lordship is going to give us a delicate 2 at 3:30.
No, we like to conclude this first. We are not going to.
Let me then take
We have got time. We have
25 minutes.
I've handed up a spiral down. I'll just quickly finish in about 20 minutes. Anyway.
But I have prepared a brief written note and rejoinder
That's right.
where I have course, this is one of those unusual cases where 3 law officers have appeared for the union. That's why we had fairly exhaustive arguments, and of course, finally the Solicitor General with his usual weight of authority suggested that we now undo.
Maybe not,
We'll continue with Jellicut tomorrow.
tomorrow morning, not
Certainly.
so today seems
Today, we don't know.
Today it won't finish.
We don't know how things will go.
One can wait, one more can wait, but I don't know if it will be possible.
That's right.
Tomorrow.
Then after
Tomorrow,
we-
10:30 tomorrow.
That will take tomorrow 100%.
No, tomorrow we are, I'm here, I'll be here at 10:30.
We don't have to wait.
I'll be here. Sorry for interruption. I'll be here at 10:30. Sorry to interrupt you.
Fine.
Lord, I'll quickly run through
Yeah.
my submissions. So the Attorney General's submissions, my Lord, if I can summarize them, I have tried to summarize them here.
Yeah.
It says firstly that this court cannot issue directions to Parliament to enact a particular law in a particular manner. That was kind of supplemented or buttressed by or slight modification by the Solicitor General, who said that there is a separation of powers under the Constitution, and therefore this court can't even say or can't even tell the government or the president and say anything about how this power of appointments is to be exercised. Secondly, Lord, he said that the appointment of members of the Election Commission is in consonance with 324. Therefore, there is neither a vacuum nor the practice of appointment of members of the Election Commission can be said to be unconstitutional. He said there is no vacuum because government is appointing, government has been empowered, and so on. Then he says that merely because somebody aspires to have a better system doesn't mean that there is a vacuum. Then he says that there is no reason to think that the current system of appointment violates any fundamental rights under the Constitution. And then he says that the Law Commission report or the Dinesh Goswami Commission or the National Commission to Review the Constitution or the Administrative Reforms Commission have not suggested, have not discussed and suggested that the Election Commission is not neutral or that its lack of neutrality is because of this appointment being done by the government. Now, Lord, my response to all this is, firstly, we have not sought a mandamus to Parliament. We are not asking Parliament, this court to direct Parliament to make any law. Therefore, this argument of separation of powers is inapplicable. We are praying for this court to exercise its powers under 32, Red with 142 and 144 to issue a direction to the government to put in place an independent, rational, transparent system of selecting the members of the Election Commission till the framing of an appropriate legislation. Article 324 merely states that the appointment of the Chief Election Commissioner and other election commissioners shall be made by the President. There is no challenge to the power of the President to appoint election commissioners. The appointment has to be done by the President as it is done in the case of Supreme Court judges. Ultimately, the President issues the notification for appointment. However, the Constitution is silent on the selection and its process. In other words, the practice and procedure for selection is not defined. Further, there is no provision with respect to qualification for the members of the Election Commission. The government has also failed to produce any procedure that is followed by the executive, and therefore there is a vacuum, and this court can step in to issue guidelines on eligibility criteria, composition of the search committee, quorum of committees, and procedures that the committee must follow. Composition of the selection committee, Your Lordship, not the search committee, of the selection committee. Because it's...
Mr. Bhushan.
Yes. Yes.
Quite apart from the fact that this is a kind of a unique situation where we are trying to do all this in the context of a constitutional provision.
Yes.
Like an ordinary executive power, statutory power. This is the Constitution itself we are being asked to make an invasion, as he calls it, transgressing on the boundaries, separating each organ from the other, number one. We'll get over that. Whatever way we have, we can do that. Perhaps. Other more important line of judgment starting like this from 1984 to SEC relating to adoption, public investigation, court issuing direction like Union Carbide, Ahmedabad Chief Judicial Magistrate case, and finally the judge's case. And of course, the CBI director case and the court issued guidelines. They were all premised on one singular circumstance, which is that in the absence of any law.
Yes,
So to begin with, there is a vacuum.
yes,
Now, here, the first question is whether there is a vacuum.
yes,
Now, if there was a vacuum, it cannot explain how for the past 70 years, we have had a long line of chief election commissioners for the first 40 years.
yes,
Thereafter, from 1989 onwards,
Yes.
a short gap, and then from 93 onwards,
yes,
we have had also a multi-member team
yes.
being appointed. Now, is there a procedure for appointment? The president appoints means under a constitutional democracy as we have, Westminster model, Article 74, Article 77,
Yes,
read with the rules of.
but I'm answering all
No,
this.
no, what you're saying is
Yeah.
not a case where there is a vacuum which has produced a corresponding infringement on a fundamental right, which again in turn is a question which we'll have to ask ourselves whether there is a fundamental right.
Yes,
So you have to link
That-
all this together.
yes, my lord, that's what I'm trying to answer.
Whether there is a vacuum.
Yes, so,
Also, you missed out one important connection by the Solicitor General.
yes,
Contented the belief that, or that is crept in, that only the presence of a judiciary will make matters transparent. That is impermissible. One should be impermissible.
I have not
Such a contention was.
I have not argued that only the presence of the judiciary. I have said that there needs to be a neutral and an independent body to select election commissioners. And the fact that there is no neutral or independent body may lead to and has led to selection of election commissioners who may not be and often have not been independent. Arguments delve into the question as to why there is reason. Now, this trigger point argument, if there has been no trigger point, etc. In the petition of the Association for Democratic Reforms, which was filed in 2021, my lord, we have not only annexed the report of the Citizens Committee, which details at great length at least 50 instances of the Election Commission not behaving independently. I didn't want to go into that because I thought it was not necessary for me to go into that. The reports, why are the Law Commission, Goswami Commission, it is said, it was argued by the Attorney General that, look, they have not gone into this matter at great length. They have not first said that the Election Commission is not behaving independently, therefore we need to put in place an independent mechanism. Or that in the absence of an independent mechanism, Election Commission will not be independent. Of course, the Citizens Committee has said so explicitly. They have said so explicitly, repeatedly. Here are the instances of the Election Commission not behaving independently. And this is why they do not behave independently, because the appointments are completely. Of course, they recognize that the Election Commission has functional independence in the sense that the government has no disciplinary power over them. But they say that it is happening because the government has complete and unilateral control over the method of appointment, and the partisan behavior of the Election Commission is writ large to see. And therefore, my lord, for us to believe that Law Commission, Administrative Reforms Commission, Goswami Commission, National Commission to review the working of all of them would make this recommendation in the air, in the absence of their not realizing or feeling on the basis of the evidence that was before them that, look, Election Commission's independence is questionable if the appointments continue to remain unilaterally in the hands of the government. As my lord, somebody said that though it is good to keep our minds open, but not so open that our brains fall out. So, I mean, one can go on saying that, look, there is no trigger point. There is no reason to believe why the Election Commission will not behave independently. There is no material to suggest that the Election Commission, I could go into that. I could spend a lot of your lordship's time. Citizens Commission has gone, Citizens Committee has gone into it, headed by Justice Lokur at great length, pointed out large number of instances. But I thought that it was not necessary to get into that because there is judicial recognition of the fact in the judge's appointment case. Judge's appointment case also, the court did not go into the material to show why the appointment by the government alone or the selection of judges by the government alone is leading to non-independent judges. They said it's given. They said this is axiomatic that if the selection remains in the hands of the government, it will lead to a great danger to the independence of the judiciary because it will lead to selection of not independent judges.
There are two questions here.
Yes.
We'll have to, again, we'll have to both Gopal, you know, also listen and they can answer. One of the contention was that if the Chief Justice is made a party,
Yes.
is a member of the collegium,
Yes.
also called collegium.
Yes.
No, you can't, you also agree that the president will continue to be the person who will issue the order of appointment.
Yes, of course.
Now, under the constitution, president means the council of ministers. Now, a three-member collegium, as you put it, the prime minister, leader of the opposition, and let's say the chief justice, as recommended by the. What will be their exact role? Will their role be that they have a panel and they recommend somebody? Then what is the role of the council of ministers? Unless we say that the council of ministers is to be eclipsed completely, in which case it will actually incur the wrath of Article 74 and the whole core of the constitution being based on, you know, council of ministers advising the president. A third party like a collegium, which you are suggesting.
But that is.
We are concerned with that.
Yes, I understand.
That is because we can't reduce our chief justice to be somebody who goes there and makes a recommendation which at the hands of the council of ministers will die a premature death. If the chief justice goes in keeping with the prestige of the office of the chief justice, it should carry enough weight that it should finally mature into an order of appointment being issued by the president. Otherwise, we'll be lowering.
No, that's true. That's the order. The order of appointment is also made by the president.
There's no constitution. There's not.
That is relevant.
You tell us what is to be done with the council. Does it have to, under the rules of business, do we then say, supposing this is a matter, see, there are matters under the rules of the entire cabinet.
Yes.
There are matters which go only to a particular minister.
This one goes only to the prime minister.
It goes only to the prime minister.
Now, they've said so. They've said so, that it goes only to the prime minister. But what I am saying is, once your lordship lays down that in order to ensure the neutrality and independence of the election commission, which is essential for free and fair elections, which is part of the basic structure of the constitution, which is part of the constitution and indeed part of the basic structure of the constitution, then the selection of the election commissioners cannot be merely in the hands of the government.
There
To
we
the extent.
we would like to ask you one more.
Yes, sir.
Those two, which will go substantially.
Yes.
Question at that. You want somebody to be appointed who will turn out to be the best man, the most independent man,
Yes.
man of integrity.
Yes.
Now, let us say that we accept your proposal. We say the chief justice will also be a party.
Chief Justice and the leader of opposition, like,
They will do that.
Yes.
Now, unless we also go ahead and say,
yes.
what are the qualifications? Who will make it to the panel? Will there be a panel of, what will be the number of persons who will be considered?
So,
The executive will prepare a panel. And if the chief justice goes there, it might be a one-day affair, a half an hour affair. It goes through the papers. We say, okay, the ACR of all these civil servants, they are outstanding. All are outstanding. From out of them, how do you select them? Okay, seniority is one criteria. Take the name of that man. There's nothing against him.
so my respectful
What
submission.
we are saying is that whether on the ground this is going to produce results.
Yes, my lord,
what we are
I-
really concerned with.
I agree, and that's why, my lord, I have said, I have pointed out that in the case of the Information Commission, this court has laid down several safeguards. One is, they have said that, of course, the Act says there is a qualification criteria under the CVC Act and under the Information Commission Act, RTI Act. And there the qualifications are mentioned, all kinds of people, not merely civil servants. And in fact, this court remarked that you've been choosing only civil servants. When there are so many other categories of people who can be appointed, who are eligible to be appointed, why don't you consider those? Why don't you ask for applications? And now they've started asking for applications, and about 500 and so applications come. And from that, my lord, there is a search committee which was also directed by the court. The search committee makes a short list. That short list made by the search committee and the criteria prepared by the search committee is supposed to be put out on a website. That's the transparency. I have mentioned all that. If your lordship just comes,
We'll go through that.
we've given.
You're commenting that. So
Even-
our fundamental issue is going to be finally whether there is a vacuum.
Yes. So there is
Without
a vacuum.
How do we step in?
Yes, my lord, the vacuum can be seen in many ways. One is when Parliament was supposed to make a law to provide for the procedure, etc., and no law has been made, obviously there is a vacuum.
So if that is so, there are many provisions in the Constitution
Yes.
which contemplates making of a law by Parliament.
Yes.
In all these cases, will this become a precedent
No.
on the basis of which we can come to court, everybody can come?
No. Not in all these cases. So that's related to the trigger. I say that there is trigger in the reports of these 5 bodies. Same thing happened in the police reforms case. In the Police Act, the appointment was made by the president of the DGP, etc. But this court said that, look, there are these 4 reports, starting with the Dharamvira committee, etc., which have been saying that, look, you need to make the police somewhat independent of the government in order to enforce the rule of law, because otherwise they act as instruments of the political executive. And therefore, in order to protect the rule of law, which is part of the basic structure of the Constitution, therefore we have to now make the following directions for police reforms, and they made fairly comprehensive 6 directions, not merely the appointment of the DGP. They also said appointment of the DGP shall be in this manner, that the Public Service Commission will prepare a panel of 3 names on this basis, and among those 3 names, the government can select one. So they made various directions about police complaints authorities, about police establishment boards, National Security Commission.
Police acts have been made. Police acts have been made subsequently or amended.
Yes, some of those acts, my lord, have been stayed by this court by pointing out that they are inconsistent with the basis on which these directions were issued.
Can we equate that with the appointment of a constitutional authority?
In my respectful submission,
It's not different.
in my respectful submission, my
It should-
lord, that is not
Whether it should
different.
be viewed differently.
In my respectful submission, there is no difference because.
They are only asking.
Yes, my lord. In my respectful submission, if there is a vacuum in the Constitution itself, suppose, my lord, the word subject to a law made by Parliament was not there. Suppose that was not there, original act was there. Dr. Ambedkar introduced that subject thinking that Parliament will make a law to provide for the procedure, etc. Unfortunately, that has not happened. One way of looking at the vacuum is that it is a vacuum created by the non-making of any law by Parliament. The other way of looking at the vacuum is, suppose this word was not there, subject to any law made by Parliament, and the original constitution just said that the election commission shall be appointed by the president. Even then, in my respectful submission, there would be a vacuum, because president, mere fact that the election commissioner will be appointed by the president does not mean that the executive will not lay down a procedure for the selection of these election commissioners. Even then, there would be a gap in the constitution. It would be a gap which can be directed to be filled if that gap has the consequence of violating either fundamental rights or violating or leading to the violation of any basic feature of the constitution, etc. And I respectfully submit that in this case, all those elements are there. And we are being asked today by the Solicitor General to put the clock back and for the court to say, no, this untrammeled power has been given to the executive. And therefore, if the court makes any directions regarding this, then it will violate the principle of separation of powers. Lord, this bridge we have crossed long time back. From Vishaka onwards, we have crossed it long time back. And this court has repeatedly said there are any number of cases now that that proposition, that kind of broad proposition is not correct. Then, my lord, para 5 of this, it is pertinent to mention that there is a distinction between the word selection and appointment in service jurisprudence. When the framers of the Constitution have used the word appointment in 324(2), then it is not possible to read the word selection in its place. In other words, the word appointment cannot be read to include the word selection. The article merely says appointment, that is actual act of posting a person to a particular office, is to be done by the president and not the selection. Therefore, there exists a vacuum. So what I'm saying is that the act of selection is different from the act of appointment. And therefore, about selection, the Constitution says nothing. It only leaves it to a law made by Parliament, which has not been made about selection, how the person will be selected, what would be the process, who would be in the selection committee, etc. That all could have been laid down, should have been laid down by a law. Therefore, there is a vacuum. And trigger, my lord, as I have said, trigger is clearly there. It's not the case that when 4 committees, 4 such eminent bodies say this, obviously there is a problem. And after that, the Citizen Commission also. There have been, then, my lord, then para 7. This Honorable Court on various occasions has issued directions or guidelines for the purpose of protecting fundamental rights or preserving the rule of law. And such guidelines or directions have been given effect of law by the Parliament through not just law.
Yes.
In the whistleblower protection case, my lord, this is what the resolution itself says. 2004, the resolution came, which put in place an administrative mechanism for whistleblower protection and made the CBC the nodal authority. And it says that the preamble of the notification reads, whereas while hearing writ petition number so-and-so regarding the murder of Sri Satyendra Dubey, Supreme Court desired that pending enactment of a suitable legislation, suitable machinery should be put in place for acting on complaints from whistleblowers.
This is that citation?
That's in the whistleblower notification. We'll hand over the notification.
You hand over the notification?
Yes, I'll hand over the
Put it down in writing. What else you
Yes,
have
yes.
to say?
It's the
What else you have to say, you can put it down in writing so that.
No, I have put it down in writing. I just wanted to, my lord, emphasize a few things that in all these cases, after the directions of the court, whether it's the whistleblower case or the
They
sexual
come out with laws.
No, first they came about with administrative notifications, putting in place a mechanism. The laws came sometimes 10, 12 years later. First, the government, because the court said that till the time that there is any law, these directions will hold the field. So they had to come out with a notification.
Correct.
So therefore, my lord, in all these cases, this happened. And even in the street vendors case, it was this court which said that, look, street vendors have some rights. You can't deal with street vendors like this. And that's why eventually that Street Vendors Act came. They have some fundamental rights. A system where there is no procedure or qualification laid down for the purpose of selection is incompatible with Article 14 of the Constitution.
Kindly give us a note for whatever you have to.
Yes, Lord, I have handed over this.
And we will go through it.
Achha, all right.
Yes, please.
And I just wanted to point out that this latest appointment of Mr. Arun Goel, this has been made by giving him voluntary retirement. Thursday, your lordship heard the argument. Friday, he was a secretary in the government, sitting secretary. Otherwise, my lord, all the people, virtually everybody who has been appointed were retired people. He was a sitting secretary, given voluntary retirement on Friday. And his appointment order apparently is issued on Saturday or Sunday. And he starts working from Monday. So Thursday, your lordship heard this case where I mentioned that there is one vacancy and I'm seeking interim orders in this case. So what process, what procedure? In one day, you rush through his voluntary VRS, you give him VRS in one day.
See, VRS can be usually given only after 3-month notice.
Yes.
Under the rules, he must have given a 3-month notice.
I doubt it. I doubt
Unless they waive it. I don't know whether they can waive it.
I doubt it very much.
Normally, they have to give a 3-month notice.
That's why I'm saying that your lordship should ask for the records of this appointment.
Well, let us see.
I don't think this is a matter in which law to enter into contest the larger proposition. I said from May onwards, this matter is lying way.
We would like to
How
know.
do we juxtapose this in the context? I mean, I'm strongly opposing this.
Sorry, Attorney General, we would like to ask you.
Yes.
We heard this case on a Thursday. Last Thursday, we began hearing this case, and then Friday we had a miscellaneous. Last Thursday.
Let me put it like this.
No, we'd like to know.
Yeah.
Thursday we began hearing. At that stage, Mr. Bhushan said we have an interim application. This is an urgent matter. Then in the interim, then the next hearing takes place yesterday. I mean, it took place yesterday. We began yesterday, on Tuesday.
I would only venture to say there is no design. I'd only venture to say.
We are not saying that.
That's
So therefore, we would like you to produce the files relating to the appointment of this officer, so that if you are in the right, as you claim to be, that there is no hanky-panky, you have nothing to fear. Do you have any hesitation in producing the file?
The question is, no, I think we talk on the field. He may have more information than me.
No, I'm speaking from the newspaper articles.
Therefore, right information travels to such a length.
Under the commission, election
But the question,
was it a case where was he appointed on the basis of what retirement? Was he an officer in service? What was the mechanism by which he was picked up, Attorney General? And it's being made when the matter is being considered by.
We are the.
That's right.
let me only information I had was.
See, when there is an application against this appointment, about the appointment of any member pending, and that the matter is being heard by the Constitution. We thought that we are saying that it would have been more appropriate.
I don't want to resist any. I don't want to resist any matter being seen.
That's right.
But to pick up a flag an issue like this and say, look here, I am bringing before you a matter of concern how there is an attempt to.
You could have.
I have strong reservations for that.
When an application is filed by a party and it is pending before us, and we have begun hearing of the matter.
No, but was it an injunction? No, was it an injunction as say that not make any appointments in the meanwhile to the election?
There was no such order.
Therefore, that was no injunction.
But then the application is there. But anyway, let that go. Let that go.
That is
We
true.
are not going to. We are not taking judgment over that appointment. But we would like to know. this will be an eye-opener because you are claiming that everything is hunky-dory. Everything is going on very smoothly, efficiently, the most competent man of integrity.
Yeah,
knows it. You have nothing. to
I would not like to venture
would
to
like to-
answer on a.
Don't answer.
I would not like to. I think it's improper on my
Yeah,
part.
yeah,
My learned friend can say anything because as I said, look here,
that's right.
just
but
before it took a voluntary retirement, that's
listen
what
to-
it means a voluntary retirement. I'm sorry.
we are only asking you to just make available the file unless you have a legitimate objection to our asking you to do that, in which case we'll withdraw the order. We would only like you to, we are only asking you because the file will be there. From the file,
Certainly.
we
I mean,
know how it
why would attorney try to keep any information from the court? Certainly.
So please,
But I would like to first satisfy myself.
just for satisfy us.
I would like to
we
satisfy
would like
myself
to
that
see that file.
yeah.
Unless you say that you would not want to, you will have some claim
Yes.
of privilege or something under which you will want to.
Let you put it like this. Well, I don't think we need to travel that length.
Why saying that it will be maybe to your advantage because then you will be able to say there is a procedure followed.
No, I quite see.
To see.
I only a small
You
response.
can't possibly sit on in judgment over the appointment. That is not challenged before this.
Certainly.
But we have for the purpose of generally understanding how things take.
This is like a drawing a red herring so that you have a. I don't think that should.
So we would like to have that. That's a different matter. No?
Let me first satisfy myself, and then if there is something to be disclosed to the court, shared with the court, certainly it's my responsibility. But to say that there is an attempt.
How will we be satisfied?
No. I wanted to say this that if I am, suppose that need to be shown to the court, and certainly.
This is a matter. We are saying this because this order of appointment was made after we began hearing the matter. When there is an application saying don't make the appointment. Is that an application?
Yes,
No.
yes.
That application is made, so we get session over it. Unless you wish to refuse to disclose it, like which case we don't think the way we know you that it's not that adversarial. We are only asking you. We just like our curiosity is intertwined with our beauty. Otherwise, we have no,
I don't think
Attorney, if I may just, Attorney General. It may not be a case of, let us say, overreaching, but overreading the mind of the court.
Whether the lines may be very thinly drawn, the lines may be thinly drawn. But I
only saying just the circumstances.
Can I not make this request to the court? We are in the realm of a larger question.
That's right. That is interlinked.
Now, the interlink is thought to be brought in to show, throw doubts, to look at you must necessarily get into the larger question.
You tell us.
I have some reservations about that.
That's right.
Because this solitary instance, you rely upon a 2019 citizens report, etc. And therefore, there's a trigger point. This trigger point is now, therefore, look at it. I have some reservations.
You have the file with you tomorrow.
Yes.
Because anyway, the way it is going, 10 minutes, I don't know, Shankaran will may have to give some more time to them. So you have the file with you tomorrow, at least with you. And if you feel that you should not disclose to us, you will not.
No. Don't take it. Please don't take
So
it.
have the file with you. That's what we are saying.
Let
Let it proceed to the matter. We are not.
See, tomorrow I am before a different
You
constitution.
can have anyone
And
who will have the file with him. That's what we only want.
it may take a.
We don't think it is a matter, where we should be withholding information. We are living in an open democracy. And this is not a matter leading to the appointment of a military person.
I don't want to give an impression that there is.
And from the court.
It is from the court.
I don't want to give an impression.
I mean, I'm not
It's all right.
asking to
It's
see
all
the
right.
facts.
I know how to handle my work. I don't have to get guidelines.
So you can just keep it with you. We are not.
The early difficulties tomorrow I'm before the different constitution. I'm able to
be.
Yes, I'll try to speed some time and find out how it. I'm trying to work out how it can be done. But I have a serious reservation on.
All right.
So, Lord, in the citizens report at page 5 of this, I have said that the citizens commission, they have mentioned many instances. I have only quoted a few of the actions of the election commission which throw doubt about its impartiality.
We are not rising. They just.
I'm sorry.
And that's, your lordship may just note the page number of the
That's right.
compilation, 999. this quotation, which is at page 5 and 6.
In your note, you are giving it.
I have not written the page.
That's all right.
I've given the note.
So we'll go through this.
No, but the page number you'll not.
We have seen.
991.
Yes.
Then the report mentions the reason why this is happening. They say one of the major reasons for the alleged kowtowing of the ECI before the political executive in recent times may be located in how the appointments to the election commission are made. While the ECI is autonomous institution drawing its powers from the constitution, the problem lies with the fact that the appointment of the election commissioners is done by the government, and that too unilaterally.
All right. All right.
This problem has always been there, but assumes particular significance.
We'll go through it, Prashant.
Thereafter, my lord, I have just mentioned two things.
We'll go through it.
Acha, all right.
We'll go through it. We'll go through it.
I have quoted the directions in that information
Yes,
commissioner,
yes.
and I have said that one disqualification should certainly be there.
Correct, correct.
That the disqualification is that he cannot be at least a member or affiliated to any political party, obviously.
That should be there. That should be.
Yes, that has to be there.
Gopal,
Wait, please. It says, there's a note and a spiral bound volume
yeah,
that I've just handed out.
Yeah.
Lordship will take that.
Yeah.
And highlight some portions of that. I just want to immediately just respond to 2 points which were made at the fag end by the learned solicitor.
Yeah.
Particularly the question
Yeah.
that came from Justice Ravi Kumar about the first one was regarding Article 53(3)(b). That has no relevance simply because of Article 73, which he didn't read, and entry 72, which he didn't read. Because it's very clear that that chapeau is completely different and wholly inapplicable. The second, about the outside presence, a word, a phrase which I find highly objectionable, and he used it thrice. The only outside presence is him. He hasn't been here. He comes suddenly and then he's disappeared again. The outside presence to be used for the Chief Justice of India or for any other authority is not a phrase you can ever employ in the context of supporting and protecting democracy and free and fair elections, which is what this case has always been about. In that, there are no outsiders. There are only insiders.
no outsiders.
So what we have recommended and we have adopted also is perhaps maybe a larger 5-member committee as you have for the Lokpal, which will include the speaker, which will include the Chief Justice of India, all insiders who will nominate a 5th jurist from the 4 of them will sit together.
Yeah.
And that would be the possible committee. I've given that recommendation. Now, if your lordship will take up this note, I'll try and see how much I can finish. Mulad, because I just want point by point. Point 1, what we did not argue, I've made it clear. All your lordships have that note, I hope, which
We have that. We have that.
we did not argue of mandamus to parliament. We did not argue to
Already
implement.
argued it. Don't repeat.
Yes. Now, the lacuna existence, I want to make 2 or 3 points about. Because I believe that when they made the argument about trigger, which all 3 of them have made, that presupposes the fact that there is a lacuna. Otherwise, we don't have to bother with triggers. It's only once you finish the lacuna stage that you come to trigger. But having said that, here's why there is a lacuna. I don't know if the lordship will have it at easy reach. There is that note that was handed up yesterday with the various provisions of the constitution. That's note 2 that the AG had handed up with the provisions extracted.
Annexure was
The
there.
annexure. Now, if your lordship, this requires a little bit of time, so the lordship don't know. Those provisions which are all set out, which employed that phrase,
You have
subject to-
You have that.
I've mentioned it, your lordship will see the second bullet point in the first page.
So,
But I feel sometimes I need to vocalize this. I mean, we waited patiently while the document is taking 2 days. So allow me a few minutes.
We give that. We give you. What
Yeah.
you want to know, you have detailed it in the note.
I have, there are some points which will supplement this, which I can only tell you.
Before you do all that,
Yes,
please tell us,
yes,
is there a lacuna?
yes,
in
very
in
much
this
so,
article? You tell us that.
very much.
That is a fundamental issue we have to deal with.
I'm
An issue which you have to frontally deal with.
I'm addressing that exactly right now.
Yeah.
I'm telling your lordship that when they use the phrase subject to law made, there are many provisions of the constitution that use that phrase. As far as appointments, services, etc., there are 2 sets of those. Let's ignore all the others which are not relevant. We have to consider posts, offices, services, and this. That's what we look at.
Correct.
Fall into 2 categories. I've mentioned those articles here.
338,
Correct. So 338A, 338B, those three, along with 324.
Correct.
Those four use it in a very special manner, very different from how it's used in 146, 148, 229, and 243K. These are the 8 provisions. There's a finite set in the Constitution which is dealing with services, employment, posts, etc. Now, first, these latter 4, 146, etc., are using it specifically by saying law made
In this
regarding
behalf,
conditions of
in
service.
this behalf.
Yes, and for conditions of some paper. In this behalf, specifically with reference to conditions of service. So it doesn't widen it for any other purpose. But if your lordship will just see 338 for a minute, 338, where the parallel is drawn, 338, 338A, 338B, all use identical phraseology. 338A, your lordships can see, which deals with the scheduled tribes. There's 338A, 2, dealing with the National Commission for Scheduled Tribes. So scheduled tribes, backward class. Subject to the provisions of any law made in this behalf by Parliament, the commission shall consist of a chairperson, vice chairperson, and 3 other members, and the conditions of service and tenure of office of the chairperson, vice chairperson, and other members who are appointed shall be such as the president may by rule determine. So the entirety of this is subject to the provisions of a law made on this behalf, in this behalf by Parliament. So I'm asking myself a question. If Parliament were to make a law which did not provide for even one scheduled tribe person in that commission, surely that would be struck down. It would be vulnerable at the very least because it is a commission for the scheduled tribes. But the provision nowhere says that you need to have a scheduled tribe person there. I'm drawing the parallel to explain to your lordships that these 3, along with the election commission, falls into a finite set where you have to make a law, which is why we have set out a chart. Just please take up the spiral line linked to this particular issue. We have set out all the constitutional authorities in a table, page 1. The 4 criterion which are necessary: qualification and eligibility, term, removal, and salary. I've given your lordships under this tabular chart, showing your lordships that of all these, where is the lacuna? And the lacuna is in 324, where it's not filled up by a constitutional provision or a statutory provision or a rule. But in every other case, it exists. It's filled up and it's answered. That's point 1, limb 1 of the lacuna argument. I'll just make that good because I need to stitch this up with what I've put here. I'm not going to take an extra minute. I will make 20 points in 20 minutes if I can, but I'll try and keep it as short as possible.
Or you can argue because we are saving time.
Yes. I'll continue. No, it's the game.
That's all right. That's all right.
Yes. The second one, that the test that your lordship should apply in examining whether there is a lacuna or not is today, can a law be made under 324 providing for a scheme or a process of appointment? Can that law provide for the qualifications that are necessary for a person to be eligible to be appointed as an election commissioner? If the answer is yes to this, there is a lacuna. I don't have to say anything more. If a law can be made.
See, your concept of lacuna
Yes.
is intertwined with the Attorney General's concept of aspirational law, a utopian law.
It would have been if they had not conducted themselves.
What you're saying is,
yes.
Can you listen?
Yes.
From 1950 onwards.
Yes.
With the first, that was Sen, Mr. Sen from Bengal.
Yes.
We have had a long line of central election commissioners followed up by election commissioners.
Yes.
There is an appointment process in place.
Which we don't know about, but it exists.
There is an appointment process.
You don't.
Legal also. It is legal. Till, we are not called upon, you have not called upon us to decide the legality of the appointment so far.
No, we're not. There's an appointment
therefore,
practice in place, not a process.
What you're saying.
Yes.
We'll give you an example so that you can understand it better.
Of course.
Supposing the same bench.
Yes.
Which heard Vishaka.
Yes.
Was hearing this case also.
Yes.
The question which it poses in paragraph 13, I think.
Yes.
Where it quotes say, in the absence of any law.
Yes.
No, there is no framework, no guideline, no law to give effect to the rights of women being harassed at workplace.
Yes,
So they drew upon international treaties,
correct.
fundamental rights, etc., and they stitched together, as
Yes.
you said, guidelines.
Yes,
Same thing happened in all the earlier cases. There was no law.
correct.
There was a complete vacuum.
Yes,
Adoption, for
Yes.
example, adoption
That's
by a foreigner
intercountry.
Indian
adoption,
children.
yes.
There is no law. So they take, this will be what it is. So
Absolutely.
if the same when we're hearing it, we are just doing it so that
Yes,
hypothetically.
no,
we
I'm
can
absolutely
decide that.
agree.
The court would come to the conclusion, no, this is not a case where there is a vacuum in that sense. There is perhaps a vacuum in the sense that you are projecting, namely,
Yes,
a lack of an ideal system of appointment. And you're right, because
Yes.
what a lot of complaints are there.
yes,
But to say legally, juridically, that there is
Yes.
no law or there is a vacuum may not be fully correct, because when the use of the word president shall appoint, it brings in a whole gamut of procedures, constitutional system contemplated, like you pointed out correctly, in the Article 73, Council of Ministers, rules of
Yes.
business, and they have been making their appointments.
yes,
You cannot characterize that as illegal. It will become illegal only if a procedure prescribed by law by Parliament is opposed to what we have said. Supposing Parliament also says continue the same thing.
That's
And
No,
put some
absolutely.
flourish.
I'm not
That's-
characterizing it.
Therefore, we have to
Yes.
address that issue.
I'm,
Because unless there is a vacuum,
yes,
we cannot say there is a vacuum.
so
There is no vacuum. I mean, supposing
Yes.
there is a vacuum, we can say there is.
I understand. So let me put it like this.
Ah.
The Vishaka bench would be told that, look, what is the principle we are looking at? The fact that women's rights under Article 21 are violated. The principle that the Vishaka bench will be told. The other bench, identical to this one, will be told what is the principle we're trying to protect here. It's democracy and free and fair elections. Democracy, primarily. The essence. Now, you have a principle then before both benches. Before one bench, you're saying there is no law at all. There is not even a scratch of it. You can try and read it into, there would have been arguments at that time saying IPC, some provisions will cover this and that. But that still is not an answer to what the CEDAW convention, which was imported there for those purposes. Here the argument is that the absence that we are seeing is a very important central aspect. It's not enough to say the president puts a warrant on the appointment, so the law is fully covered. It's not enough. And that's our argument. Our argument is that the minute you don't have anybody but the executive deciding on the individual or set of individuals who are given the solemn charge of this basic principle of upholding democracy by having free and fair elections, minute you don't have independence in that, that is a gaping huge vacuum. The fact that you don't have independence in the appointment process, that's what the vacuum is. We are not saying that everything regarding election commission, it's not like we don't have an election commission. We have an election commission. Nobody's done that. It's not like we didn't have a Supreme Court. We have.
Same thing with police
The-
reforms.
With police reforms, with administrative reform. What are we doing here? We are moving forward with the constitution based on the experience that we have in society and in polity. Those experiences.
That is an area actually largely governed by value judgments.
Yes, of course.
It's related.
Yes, it will be.
To you,
Yes.
there is a gaping hole.
Yes.
To them, there is a system in place.
Yes.
A system in place which has turned out eminent, perhaps less eminent, competent, very competent.
There may well be.
But related.
There may well be.
But there have been individuals, and it is not as if without an election commission, the entire machinery which it has, rules which they have, because when you talk about independence,
Yes.
please remember one thing.
Yes.
Independence is not an unruly horse that a person can ride and say
True.
that I can do whatever I do.
Correct.
Independence partly at least partakes of playing by the rules of the game.
Yes.
Supposing the election commissioner, chief election commissioner is there is a rule. Then I will overlook it. That is not independence.
Right.
In areas where he has discretion,
Yes.
he exercises discretion, he shows his independence. Fine.
Yes.
So therefore, if there are, it's not as only with the persona of the chief election commissioner fitting the bill in terms of, independence, which again is cast in absolute terms,
Yes.
that everything else will follow. May not be.
No, it won't. It won't. We are not at all assuming that this system will make everything perfect. It won't. There's no question about it.
Oh, you have got that.
No,
We'll give you some more time tomorrow, but try to.
I'm sorry, you are making submissions tomorrow.
Yes,
Two things.
yes.
The hammer is on rules Parliament has to frame. Suppose we delete it, it would not have been there in the constitution,
The phrase subject
the
to
phrase,
law. Yes,
not have been there.
yes.
Like when you go for appointment of a commission, chairman of a commission, public service commission,
Yes,
there is no such requirement of.
yes,
Okay,
yes.
now also the union government or the state government make appointment of a commission chairman.
Correct.
And the members,
Yes,
and there is no requirement of subject to framing of rules.
correct.
So if this particular phrase, addition
Yes,
of subject to rules being framed by the parliament,
we're not there. in the-
but not there in the constitution.
Yes.
What will be the
I
situation?
would still make the argument, and I'll make the argument.
So according to you, if that would not have been there,
Yes,
still you will hammer that there is a vacuum?
yes, I would still argue that.
All right.
I would still
So
argue.
keep it in mind.
Yes.
So we said 20 minutes yesterday, today I've given you extra 10. So we'll give you, sorry for the questioning, we have
No,
to.
no, I want to respond.
Only one line, my lord. If
I want to respond to those questions.
only one line, if I learn.
Tomorrow by 11 we'll start, 10:30, 11 by we'll
What
start.
Yes.
Can I, can I have only a second?
Treaties will not.
If-
Osaka international treaties is there. Here is also international treaties and Indian.
There is no international treaty.
But can I have 1 minute? When I said outside prison, it was obviously outside the executive. The lordships have understood. Everyone is not ours, outside the executive. Let it not be misunderstood by your lordship.
You called out chief justice, that is what he said.
That's
One-
not his op.
All
That's what I don't have the lordship. I'm not just trying to,
That's all.
your lordships have understood, my point, outside the executive.
We have understood. We have-
Lordship,
Both of us.
this intelligence, in case I have to be in the other constitution tomorrow, I hope either the solicitor somebody will be able to answer that other issue.
Please produce that,
Will that?
please,
And then
otherwise.
I've seen the application says the direction that the appointment shall be made by a collegium. That is the direction.
That's right.
Right. Therefore,
So when you
if we
look at-
take it as an injunction that no
We hope
appointment
you
in
don't-
the meanwhile,
We don't want to be confronted.
I.
But we hope we'll
it
produce
brings
a
in it
file
brings in an
just for us to peruse it.
Yeah.
If you, there's no danger in permitting us to produce it. We happen to be judges. We happen to be.
I only trying to express my, and then
We
finally.
happen to be judges of the court. We are hearing this matter. That's all.
I hope I made myself very clear.
Yeah, but then you will produce it tomorrow.
And-
Yeah. But if after that we start delegate, we'll come in this thing up tomorrow.
Also like.
We have said that. We have said that.
So 10 minutes will not.
No, whatever is it, by 11 sharp, whatever argument is there, it will be over, it will be reserved, yes.
Very good. Great.
Yeah, please. Hello. Please answer. Before the break, Justice Rastogi asked me a question that since in case of a Delhi High Court CAG appointment, there was some narration of the process which has been undertaken. Well, may I request the learned AG's note which he handed over in the morning for a minute, if my lords can see.
Para 6.
Para 6 months. Well, this was 4-pager note. Note which was given. I'll just pass one more.
Called a supplementary note.
Yes, we got it. Please, lords. Para 6 months. On the second page. Start with by convention. Yes, may I please know? Just one aspect I would add to it, Alan. By convention, it has been established that the members of senior civil services
other serving or retired officers with the rank of a secretary to Government of India, Chief Secretary of State Governments have been appointed as Election Commissioner, and the senior most election commissioners as Chief Election Commissioner on the basis of the database maintained by the DOPT. A list of serving and retired officers in the position of Secretary to Government of India, Chief Secretary in States is prepared. On this basis, a panel of name is then prepared. What is missing, one of the instructions are by Ministry of Law for consideration of the Prime Minister and President. The Prime Minister, after considering the panel of names, recommends one name to the President of India. A note with the recommendation is submitted to the President of India. This is the convention which is being followed. So there is a process of DOPT maintaining the list of different officers serving, and the DOPT maintains including their career track records. It is not that they only maintain that who's the senior in each ministry. So there is a lot of data being collected, and as I'm privy to, since I was arguing on reservation matter. So when they calculate, it's a very, very comprehensive data which is being maintained. Right today is to be identified in railway particular department, particular section, who has been appointed, his origin date of appointment, under which category, through the interview rules, through the promotion rules, which postings he had been. So all those details are being maintained. Once that list is prepared, based on that, the panel of name is given by Ministry of Law. And like any ministry, they have their own ways to look at it, which is being carried out. And based on that, the list goes to the Prime Minister with the note of recommendation.
Has there been any occasion when you have overlooked the senior most election commissioner in the matter of appointment of the chief election commissioner?
Because I can check that, but I mean, right now may not be positioned, but I can take this question and can.
We just wanted to know.
Yes,
if you are given the right to supersede,
yes,
then you will have yes men. You'll be queuing up and they'll do whatever you want them to do, so that they get to the post and satisfy them. Completely erodes seniority. I mean, independence.
Well, that can be one way to certainly that there is a possibility.
You don't know how you do it.
Yes, but
big system.
Then I think is going to be most important question would be. I mean, I'll certainly answer this one. I'm duty bound to answer this. But in each of these cases, that to what length this inquiry is to be made. We were on a convention that there's some convention which is being followed. There is some method which is there. And that method has got some basis to go because the DOPT being the highest authority which is maintaining the employment record of Government of India in different ministries. And that carries out and the panel goes to the respective ministry, which is Ministry of Law. There is some exercise carried out, the final panel name is given. So far as this is the process which is being carried out.
Yes.
I wanted to show that it appears that what is the current setup of the election commission in the country, because one aspect was raised that the need a separate secretariat. There is the independent secretariat, but currently this is available on their website also. So it's not I'm taking something from outside. That what is the current structure of the election commission?
May I just take a moment? Because the estimate on both sides is that it will continue in the day 501.
May not. We have said maybe at least by half an hour we'd like to devote to.
All right, very well. Then
we want to begin.
No, very well. No,
by 3:30.
No problem.
So, to your lordships, would like to continue tomorrow?
Of course, we depend.
Tomorrow
we'll be continuing. We will not be breaking up the constitution bit. After this is over, it's take the delegate.
Your lordship
will continue the bench. No.
Tomorrow, there is another constitution bench, but there's no problem.
True. But then we will not break up this bench. That's all we are saying. Who wants to address this in delegate?
In any case, we have to address, Lord. Well, in this matter, we would like to respond after Mr. Sharma and Mr.
That's right. We are going. Let's see how we begin. Yes.
Well, let's kindly see the setup which has been explained.
Yes. But we just keep a time on.
Well, I'll wrap up in 10 to 15 minutes. Yes. The commission has a separate secretariat at New Delhi consisting of about 300 officials in a hierarchical setup. 2 or 3 deputy election commissioner and the director general, who are the senior most officer in the secretariat, assist the commission. They are generally appointed from the national civil service of the country, are selected and appointed by the commission with tenure. Directors, principal secretaries, secretaries, under secretaries, and deputy secretaries support the deputy election commissioner and director general in turn. There is a functional and territorial distribution of work for the commission. The work is organized in division, branches, and sections. Each of the last mentioned unit is in charge of section officer. The main functional divisions are planning, judicial, administration, systematic voters education, and electoral participation.
Read it as read, David.
Yes, so one can take it that.
Yeah, that's noting it, set up.
Yes, so there is a setup. Now, this setup linked with, if my lords can take the People Representation Act of 1950, 1950 People Representation Act.
1950 Act.
50 Act. The endeavor is to show how the statutory breakup of the administration of the entire exercise, going up to the last mile of declaration of result, and what is the
judiciary, executive, and legislature. There is a theory of doctrine of the doctrine of separation of powers. But Lord, your lordships were pleased, my lord, just mull over it, my lord, as a my lord, loud thinking that maybe the presence of someone else might ensure, as my lord, going by the reports, that things are not messed up. Lord, there I have a serious problem, my lord, as an officer of the court, and please don't take this otherwise. This is my submission as a constitutional proposition, not individuals or institutions, as a constitutional proposition. But constitution makers were very, very clear that some of the powers are vested upon executive and legislature, and some of the powers are vested only on the judiciary. The distinction was some of the powers the constitutional framers thought should be entrusted to the people's representatives chosen by the people who are answerable and accountable to the people every 5 years. That's why, my lord, this separation of powers. One organ will not entrench upon another organ. Second organ will not entrench upon the third organ. That's how, my lord, the balancing system in the constitution functions. Now, my lords, if your lordships were to consider that someone else, the presence of someone else might help the situation, what are the problems? Constitutional problems. I'm not on individuals or institutions for that matter.
Why you're asking someone else? We never proposed someone else.
No, there was a, my lord, that for example, my lord, presence of the Chief Justice of India or some judge of the court, that fell for, as a
There's a kind of a deliberations going on.